Good morning. Let the record reflect that the defendant is present along with counsel for the defendant, Assistant State Attorney. Both sides ready to proceed.
Yes, sir.
Okay, who will be the defense's first witness?
It would be Cindy Anthony. If I can have just 3 minutes, Your Honor. We're still marking items for exhibits.
That's why I asked y'all to be at 8:30, folks.
We have been, and there are some things that we wanted to add that weren't previously there.
Okay, let's get to it.
Yes, sir.
Okay, what are y'all trying to mark? Okay, let's return to jury.
All rise for the jury.
Good morning, ladies and gentlemen of the jury. Did you heed all of my previous admonitions? Okay, does the state recognize the presence of a jury? And does the defense?
Yes, sir, we do.
The defense may call their next witness.
The defense calls Cindy Anthony.
Stand here, please, ma'am. Raise your right hand and start loud.
Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth to help you God?
So help me God, yes.
Thank you.
You may proceed.
May it please the court. Mr. Rain. Good morning, ladies and gentlemen. Good morning, Mrs. Anthony.
Good morning.
I wanted to talk to you, ma'am, about the shorts that Kaylee was found in when they found her remains off Suburban Drive. You've seen a photograph that's been introduced into evidence of those shorts, correct?
Yes.
And you testified previously that the shorts no longer fit her?
I testified that she was at the last time I saw her, she was in 3 toddlers, 3T.
And though that photograph was taken, you said early 2007.
Yes, I believe it was spring of 2007.
Is Kaylee like every other child that grows incredibly fast or grew incredibly fast?
Kaylee was on the high end of the growth chart, yes.
Okay. And that day when that photograph was taken, you actually videotaped her on that day, did you not?
Yes.
Okay. And I'd like to bring up the video so you can see and identify.
Basis of objection.
Relevance.
Approach the sidebar. You may proceed.
Thank you, Your Honor. Mrs. Anthony, you've had a chance to review this video,
Yes.
correct? And it is the video that's marked Defense EH. Mrs. Anthony, may I approach the witness, Your Honor?
You may.
Anthony, how are you?
And ma'am, is the video a fair and accurate representation of what Kaylee's size was back in early 2007?
Yes.
And is it a fair and accurate representation of what occurred, of her size and everything, and her interaction?
Yes.
Judge, at this time, we would move defense item EH into evidence.
It'll be entered in evidence as defense numbered.
We would at this time like to publish that video to the jury, Your Honor. See it? Can the ladies and gentlemen of the jury see it? Let's play. Mrs. Anthony, how much had Kaylee grown since this video was taken?
She's grown quite a bit.
Okay. And how do you know this video was taken in early 2007?
Because the date stamp on it says April of 2007. And I remember the clothes I was wearing that time, the skirt that I was wearing kind of was out of date after that. I didn't wear it much after that.
You've seen, what you're referring to are things that we haven't seen.
No.
Correct. And you've seen this video numbers of times.
Yes.
And you were wearing a skirt that was out of date?
Sustained.
Can you tell us exactly why you believe that was taken early of 2007, aside from Kaylee's size?
I watched that video hundreds of times since I haven't seen Kaylee in 2008, and there's still pictures of me holding Kaylee on the same day. And I recall the skirt. It was like a Hawaiian print. And even though I still have the skirt, I hadn't worn it. I don't recall wearing it after that. It was kind of like not popular after that.
Okay. I'd like to now show you photographs that have been marked. I'd like to show you Defense Exhibit A. May I approach the witness?
You may.
Do you recall I've shown you this photograph and you've testified about it previously?
Yes.
Okay. And is it a fair and accurate representation of you and Casey at your brother's wedding?
Yes.
Judge, at this time, we would move Defense Exhibit A into evidence.
What says the state? Relevancy for this testimony?
If you like, I could proffer at sidebar. I think it's
You
been
may.
made relevant.
Objection sustained.
Mrs. Anthony, I'd like to now show you a photograph of Defense Exhibit D-O. May I approach the witness?
You may.
Do you know what that picture is of?
Yes.
And can you tell the ladies and gentlemen of the jury what it is a picture of?
It's a picture of our backyard swimming pool.
Okay. And is that a fair and accurate representation of what the pool looks like with the ladder connected?
Yes.
Okay. At this time, Your Honor, we would move Defense D-O into evidence.
What says the state? We received an evidence that states that defense exhibit numbered
47.
I would ask to publish it to the jury, Your Honor. Mrs. Anthony, does this ladder disconnect?
Yes.
Okay. And can you use the tool there and show the ladies and gentlemen of the jury how you would disconnect that ladder?
Right at the top, there's a little hinge there, and you just lift it up, and then the ladder comes off. You just pick it up, and it comes off.
Now I'm going to show you Defense Exhibit DS. May I approach the witness, Your Honor?
You may.
And what is the photograph that I've just shown you, ma'am?
It depicts where we would place the ladder after we removed it.
Okay. And is it a fair and accurate representation of what your pool looks like when the ladder is down or
Yes.
off?
Yes.
Your Honor, I would at this time move into evidence Defense Exhibit DO.
What says the state? You received an evidence as defense exhibit numbered.
May I publish that to the jury?
Yes.
May I approach the witness?
May.
And is that another photograph of your swimming pool?
Yes.
And is this just a slightly different angle of what the ladder looks like when the ladder is off and off the pool?
Yes.
Is it a fair and accurate representation of such?
Yes.
Judge, at this time, I would move into evidence Defense Exhibit DT.
What says the state? It will be received in evidence as defense exhibit numbered.
49.
May I publish to the jury?
You may.
DU. May I approach the witness with DU?
You may.
Do you know what that photograph is of, Mrs. Anthony?
Yes.
Would you like to take a break? Do you need a break?
No, I'm okay.
Can you tell the ladies and gentlemen of the jury of what that is?
It's a picture of Kaylee walking up the ladder, and I'm behind her, holding her.
Your Honor, I'm going to object. This is not an item in evidence, and we can approach it for relevance.
Okay, approach.
May I approach the witness, Your Honor, as we proceed?
Yes.
Mrs. Anthony, I'm showing you a photograph of DU. When was that photograph taken?
I believe it was the summer of 2007.
Okay. And this was approximately 1 year before Kaylee passed away?
Yes.
Okay. And is that a fair and accurate representation of what it depicts?
Yes.
Your Honor, at this time we would move item DU into evidence.
Noting, let me see this. Noting previous objections, the objection would be overruled. It would be received in evidence as defense numbered.
May we publish to the jury, Your Honor?
You may.
Since this photograph was taken, can you describe what you're doing here, Mrs. Anthony, or what Kaylee's doing?
She was climbing the ladder, and
And how much are you supporting her in her efforts?
my hands are on her, but not firmly. They're right there, just like a light touch.
And after this time period, as the year went on, did she become better at climbing the ladder of the pool?
Oh, absolutely. Even at that point, she could climb into the pool by herself.
And for safety reasons, you would always just be there as a safety net.
Yes.
I would like to now approach the witness, Your Honor, with Defense Exhibit DV.
You may.
And what is that photograph of, ma'am?
It's Kaylee still climbing the ladder. It's just another image from the last one.
And is that where she's a little further along up the ladder?
Yes.
Is that a fair and accurate representation of what it depicts?
Yes.
Your Honor, at this time we would move Defense Exhibit DV into evidence.
What says the state? Okay. Objection will be overruled, be received in evidence as defense exhibit number.
May I publish to the jury, Your Honor?
You may.
May I approach the witness, Your Honor?
You may.
May I unpublish, Your Honor?
May.
What is that photograph, DW, of Mrs. Anthony?
It's Kaylee that same day when she made it to the top platform of the ladder.
And is that a fair and accurate representation of what that depicts?
Yes.
Could you read the letters on the back? I want to make sure we're getting. Is it DW?
Yes, DW.
Judge, I would at this time move DW into evidence.
What says the state? Objection will be overruled, be received in evidence as defense exhibit numbered.
Number 52.
May I publish to the jury?
You may.
May I approach the witness, Your Honor?
You may.
Mrs. Anthony, what does the photograph depict that you're looking at?
It shows me attempting to go around Kaylee as I usually did. I mean, we used to have Kaylee sit once she got to the platform with her feet on the first step in the water, and then whoever was with her would get around that way. We would get in the pool before her and then receive her.
And is that a fair and accurate photograph of what it depicts?
Yes.
And the letters on the back side of it are?
DX.
Judge, we at this time would move Defense Exhibit DX into evidence.
What says the state? Objection to be overruled will be received in evidence as defense exhibit numbered.
Number 53.
May I publish to the jury?
You may.
Now, Mrs. Anthony, this is a photograph of Kaylee on the first step getting into the pool?
Yes. The first step on the inside ladder.
Now, you're actually behind her, correct?
Yes.
Did she often get anxious to get in the water and sometimes want to get ahead of you?
Overruled. You need to repeat your objection. The court reporter did not hear your full objection.
I said objection to relevance. It's also improper opinion testimony.
This,
Just a second. As to the overrule.
you can answer.
For the most part, she, would just sit there and wait for us. Occasionally, especially as she got older, the following year she was a lot more anxious because she was more familiar with the pool. As she got older, she would run, but we'd still have her wait. But we always had a life jacket on her. So.
And during the summer of 2008, how often did Kaylee go swimming?
I can't remember when I put the pool together. It was probably sometime, maybe March or April. So she probably would have swam maybe 3 to 4 times a week.
And that was always with the life vest on?
Yes.
And when you were on vacation during June of 2008, you had, was it 1 week or 2 weeks off?
I had 1 week off at that time.
Okay. How often during that week did Kaylee go swimming?
Every day.
Your Honor, may I approach the witness with defense DY?
You may.
Can you tell the ladies and gentlemen of the jury what that photograph is of?
Yes, it's me entering the pool and holding on to Kaylee, and Kaylee was in the pool.
And is that a fair and accurate depiction, representation of what it depicts?
Yes.
Can you read the letters on the back?
DY.
Your Honor, at this time, we would move Defense Exhibit DY into evidence.
What says the state? Same objection. Objection will be overruled. Will be received in evidence as defense exhibit numbered.
May we publish to the ladies and gentlemen of the jury, Your Honor?
You may.
Mrs. Anthony, is this at a time period where you're trying to get into the pool?
Mm-hmm. Yes.
And does Kaylee appear to be anxious to swim off, but you've got to hold her?
Yes. Once I made it to the other side and got my feet in the water, it was usually okay for her to start going in. I had to be at least on the other side of the ladder. But yes, she was anxious to get in.
And did you take numerous precautions around the pool with Kaylee?
Yes.
Can you share with the ladies and gentlemen of the jury some of those precautions that you would take?
We made sure that once Kaylee started walking, we used to have a pool deck, a pool box, a deck box right next to the pool, and it was just a little bit further from where the ladder was in that picture where it showed that the ladder was down. And once Kaylee was a toddler, we moved that and put it up against the house where you can see in the background where it looks like a ficus tree, and then there's 2 hangings on my house right back there. It was below that where the tree is, right below that area. We put the deck box so that she could not climb up on the deck box to get into the ladder. And we took extra precaution every day to keep the ladder off the pool unless we were going swimming. And then we put it on and then we take it off. We also made sure that we taught Kaylee that she had to be with us, one of us, to go into the pool, and that she had to wait for us. We took precautions on teaching her how to go up the ladder and down the ladder, backwards and forwards, just like you would stairs in a house, so that we knew she can come up and down, but we told her that, we had to be with her, and why. We showed her why she could get hurt. And we kept the life vest inside the back patio. Kaylee's wearing a swimsuit at that time frame with one of those.
Let me stop you there. Did this vest fit her a year later, or did you buy another one?
No, that one was actually the second one we had bought for her. she grew out of the first one, and then she grew out of that one, and we actually bought a removable life vest that would go over her suits.
Now, these photographs, they were taken after the video that we showed the ladies and gentlemen of the jury first, right?
Yes, a few months later.
And she even outgrew this vest as well?
Yes, by the following summer, she had outgrown that vest.
Okay. Now, I'd like to show you Defense Exhibit EB. May I approach the witness, Your Honor?
You may.
Can you tell the ladies and gentlemen of the jury what that photograph depicts?
It's a picture of Kaylee at the sliding glass store from the living room going into our screen patio.
Now, does Kaylee appear to be much bigger in that photograph?
Yes.
And is that a fair and accurate representation of what that photograph depicts?
Yes.
Your Honor, can you tell us the numbers on the back?
EB.
Your Honor, at this time we would move Defense Exhibit EB into evidence.
What says the state? Objection be overruled. Received in evidence is Defense Exhibit numbered.
Your Honor, at this time we'd like to publish this photograph to the jury.
You may.
Prior to the last time you saw Kaylee, was she about this height, or was she bigger, or can you describe her size?
She may have been an inch taller. It's hard to. Just trying to figure out where that door would hit me. She might have been a little bit taller, but she was also wearing tennis shoes in that picture, so it might be the accurate height if she was in her bare feet versus those tennis shoes.
And did Kaylee ever leave the house barefoot?
You mean to go out in the backyard?
No, I mean leave the house to go to the store or things like that.
No, we always, I'm 99% sure that we put shoes on her every time we went out. She liked to wear shoes, actually.
And was it your custom to always put shoes on her?
Yes.
Was it Casey's custom to always put shoes on her as well?
Sustain this to the last question.
And the sliding glass door that you have here, I know some of them have like bars that preclude them being opened. You don't have one of those on this door, do you?
No, we didn't put one in, no.
Okay. Now, could Kaylee open doors fairly easily at her age?
Yes, you could.
Okay. All right. Can I unpublish?
You may.
Everyone. Now, On June 16th, 2008, did you come home and notice that the pool ladder was up as depicted in the photographs?
You mean on the?
The ladder.
Yes, it was it was attached to the pole.
And was that a highly unusual event for you to see that?
Yes, so much that I called George at work to see if he had left the pool ladder up, because I also noticed that the side gate was open at the same time.
And the next day, did you go to work and tell anyone?
Yes, I think so.
Who did you tell when you went to work about the pool ladder being on your pool?
It was probably either Debbie or Charles or both.
When you say Debbie, are you referring to Debbie Bennett
Yes,
or Debbie Polisano?
Debbie Bennett.
Okay. Would you have told Debbie Polisano?
If she was back in our work area, she might have heard me say that. A lot of times when I come in the morning, Deborah Polisano would be in the kitchen, which was right next to our work area, making a cup of coffee. So we had cubicles, so you could hear just about everything that went on in the back if you were back there.
And why did you tell your coworkers about the pool ladder being up?
Sustain.
Now, during this time period that you were, June 16, 2008, were you having any marital problems?
Sustain.
May we approach on this?
You may.
Judge?
Okay, ladies and gentlemen of the jury, we're going to take our standard 15-minute recess unless you want another one, a special one. That would be nice. Okay, we will, to 25 minutes past the hour, that should be enough time for you to take your special recess. I'm going to ask you not to discuss this case among yourselves nor with anyone else. We'll be in recess to 25 past. You may be seated. Let the record reflect that the defendant is present along with counsel for the defendant, assistant state attorney. I've reviewed the Mateo case, which is found at 932 7 2nd 376, a 2006 decision of the 2nd District Court of Appeals dealing with the issue of theory of defense. Exactly, Mr. Baez, and you correct me if I'm wrong, but your theory of defense was that this was an accidental drowning, that your client's behavior subsequent to the drowning was caused by long-term sexual abuse of Miss Anthony at the hands of her father and brother. Correct?
Among other things, yes.
Well, among other things, like what? Because that's the only thing you said in your opening statement. I've reviewed the case. I've reviewed the cases that are cited within this case. And all of these things, the Mateo case had to do with issues of police retaliating. In Mateo, the state had agreed to stipulate to a tape where the witness who was going to predicate the tape became ill, was going to have surgery, and couldn't show up, and then the state sort of semi-reneged on their promise and then interposed an objection of relevancy. And as long as the evidence is relevant to that particular issue and also admissible, so what is your theory of defense? Because you cannot use the broad blanket of theory of the defense to just get any and everything in. So if I'm mistaken, and the only thing I can base it upon is what you said in your opening statements, that's why I admitted the photographs of the victim, Kelly Anthony, climbing up the steps into the swimming pool. Now, if your theory of defense is ever changing, maybe you just simply need to tell me what your theory of defense is. At least somebody try to explain it to me. Yes. Okay, let's have the witness resume the witness stand. Let's have the witness resume the witness stand. Okay, let's return to jury. Okay, state recognized presence of jury. The defense,
Yes, sir, we do.
you may continue.
Thank you, Your Honor. Mrs. Anthony, on July 16th, 2008, did you advise the lead detective, Yuri Melich, about the ladder being left up on the pool?
Objection, hearsay.
Hearsay, it's her statement.
It's not a
Overruled.
statement.
Question, would you advise an answer should be either a yes or no answer?
Yes.
And was that within 24 hours of calling the police?
Yes.
And how many times have you advised law enforcement that you thought Kaylee had drowned in the pool?
Objection, Your Honor.
This rebuts recent fabrication, Judge.
There's nothing.
Sustained.
Was this a topic that you constantly brought up with law enforcement?
Same objection.
Approach the sidebar. Objection sustained. Next question.
We have no further questions for Ms. Evans.
Cross-examination.
Do we have a moment to mark some photographs, Your Honor?
You may.
Thank you. Good morning, Ms. Anthony.
Good morning.
Even after your granddaughter Kaylee was missing from your home beginning in June of 2008, you maintained her bedroom, correct?
Yes, I did.
You kept all of her clothes in the drawers?
Yes, I did.
You even kept any presents that she had received because while she was missing and before her remains were found, she had a birthday.
Yes.
In the past, as Kaylee began to outgrow certain clothing, you would have garage sales, correct?
Yes, ma'am.
And you would get rid of clothes that were too small,
Some of them, yes.
right? Or you would store them in plastic containers so that they could be maintained, perhaps to sell later or for some other purpose.
Correct.
On June 15th of 2008, was Kaylee potty trained?
She was pretty much potty trained, but we would still carry diapers if we went out. A lot of times she would just wear little panties.
Underwear?
Yes, underwear. And if we were at home, then that's what she would wear. If we went out, we would have pull-ups on her just in case we were driving or someplace where we couldn't get to a restroom quickly. Little kids usually wait till last minute to tell you that they have to go. So
When did Kaylee make the switch from full-fledged diapers to pull-ups?
oh, wow. I don't know, probably sometime early of 2008.
In the photograph, which is introduced as states 314 in evidence, may I approach the witness? Is Kaylee wearing a diaper, a pull-up, or underwear?
It's hard to tell.
I don't think the photograph calls for speculation.
If
Oh,
she's
Based on
Overall.
that photograph, it calls for speculation.
Overall.
It looks like either a pull-up or a diaper. It doesn't look like a panties. It's up, it looks like it could be a diaper
all right.
or a pull-up.
There's something coming out of the back of the shorts.
Yes.
Is why you're making
Yes.
that assertion. And it is your testimony that she was wearing those pair of shorts in April of 2007, correct?
Yes, ma'am.
Okay. You recognize in prior testimony in this court that you've said that those pictures were taken shortly before her second birthday, which would be August of 2007, correct?
Yes, ma'am.
Proper impeachment.
Overall.
Yes, I stated that it was, several months before her second birthday.
Okay. So in 2007, based on the testimony that you've already given here this morning, Kaylee was still wearing diapers.
Yes.
If I may approach the witness with a series of photographs marked RF, RE, RG, RH, RI, RL, RK, and RJ for identification.
You may.
Who did the laundry in your house? I think we talked about this before.
It would George, myself, or Casey. It was mostly myself or George.
Who bought Kaylee's clothing?
Casey and I, and relatives and friends. I mean, typical. She got a lot of gifts, but primarily Casey and I did.
Did you do a lot of shopping at Target?
Yes, ma'am.
You recognize that the Circo brand on a lot of Kaylee's clothing is a Target store brand, correct?
Yes, absolutely.
Can you take a look at those photographs that have been handed to you and tell me if you recognize any of the clothing in the photographs? If there is something that you don't recognize, segregate that out.
Object at this time. These photographs do not show clothing, they show tags.
Tags on clothing.
Objection overruled. She's just looking at them for now. She's not testifying to them.
Do you recognize everything in all of those photographs?
The only one I'm not certain of is RE. I'm not sure if that's a shirt or a dress, and I can't, it looks familiar, but I can't say what it is.
All right, keep that one aside then. What do you recognize the other items to be?
Mostly tops and a pair of shorts, one pair of shorts that's Kaylee's.
And where do you recognize them from?
Her room.
Were those clothing items that were in Kaylee's room in June of 2008 and maintained there by you until they were seized by law enforcement?
I believe so.
So what size clothing did you have in Kaylee's drawers?
I had 2 T's. Those depicted 2 T's, but there was 3 T's as well.
Now, like many children, Kaylee was a little bit stocky when she was a baby, correct?
Yes.
And as she got older and more mobile, she began to thin out.
Yes.
That process takes place, or took place with Kaylee, sometime between the age of 1 and 2, and as she becomes even more mobile as she approaches the age of 3. Correct?
Yes.
It would be fair to say then that there are clothing items that Kaylee had that could last for as much as a year, even if she's growing taller. Correct?
Yes, ma'am.
These shorts that we looked at states 314 in evidence, and the ones displayed in the video that we saw during your direct testimony Those were shorts that were kept in your house, weren't they?
Yes, ma'am.
When was the last time you saw them?
Sometime in 2008, towards the end of 2008. Those shorts?
Yes. When
The-
was the last time you saw them before June 16th of 2008?
Oh, you mean, what, excuse me, I'm not sure. Are you talking about the pictures you just showed me? Okay, I thought you were talking about the pictures we just looked at. I'm sorry. Okay.
Were those shorts kept at your house?
Those particular shorts, I hadn't recalled Kaylee wearing those shorts for some time.
The question was, were those shorts kept at your house?
You mean every day? There was several pieces of clothing throughout Kaylee's life that wasn't at my house every day.
Would that be because they were packed in some sort of diaper bag or backpack?
Calls for speculation. The witnesses testify she hasn't seen the shorts in over 6 months. So the question is posed to ask her to speculate.
Overruled.
Can you repeat it?
We were talking about the fact that there were clothing items that you would have recognized as having been in the home because you washed the clothes
Right.
or you bought the clothes that were sometimes transported in a diaper bag or in a backpack,
That's correct.
correct? And then you had seen or had knowledge of that diaper bag or backpack being placed in your daughter's car, correct?
Yes, or my car.
Or your car or your husband's car,
Yes.
whenever you all might have taken Kaylee somewhere.
That's correct.
You had a change of clothes
Yes.
with you. So do you have any recollection as to the last time you may have seen those shorts that are in the photograph that I handed to you or that had appeared in the video that you indicate was taken in early to mid 2007?
I'm sorry, can you repeat that one more time? I just want to make sure I get on the same page.
When was the last time you saw those shorts?
Those weren't shorts that I dressed Kaylee in quite a bit. I mean, there was quite a few things that I didn't dress Kaylee in, and that outfit was not one of my favorite outfits. And she had more clothes hanging in her closet than she did there. So unless Casey had her in them, and she may have worn them after, but I didn't see her that much after 2007. I do not recall seeing Kaylee in those shorts after 2007.
Okay. The photograph and the video taken of her in the shorts was taken at your house, correct?
Yes, ma'am, it was.
So you would agree that it stands to reason that at some time those shorts were kept at your house?
Yes, like I said, they were at our house, but I can't say they were there every single day. Yes.
Okay. The picture of the ladder that you testified about, how heavy is that ladder?
I don't know the actual weight. I know I can't lift it with one hand. I have to use two hands to lift it.
You would agree that it is nothing that Kaylee would ever be capable of moving or manipulating on her own, correct?
Correct. She could not.
How heavy is that sliding glass door that you showed us in the picture with Kaylee touching the handle?
You have to put a pretty good force to it to open it up.
Now, even though Kaylee was 2, almost 3, the last time you saw her, she was a very compliant child.
Yes, ma'am.
And it was your testimony that you were very careful to give Kaylee instruction about whether that's going outside or putting on any sort of life vest or climbing up the ladder of the pool.
That's correct.
How deep is the pool?
I think we went through this before. It could go up to 4 feet, but we don't fill it naturally all the way to the top, so it's just a little bit under 4 feet.
Standing outside of the pool, can an adult reach in to retrieve objects in the pool if they are not at the edge?
You have to be at the edge of the pool to reach in and get an object.
Okay. If an object is not at the edge, but you are, can you reach in and retrieve it without getting wet?
No, not unless it's within a few inches from the edge of the pool.
When was the photograph taken of Kaylee at the sliding glass door?
I can't tell you a month, but I would say it was probably the spring of 2008.
I also imagine that you would never permit Kaylee to be left home alone at your house.
Absolutely not.
One of the things that you testified on direct examination had to do with the incident that you discussed relative to the ladder being back on the pool and the side gate being open. Remember
Yes, I
talking
remember
about that?
Yes.
It was your testimony on a prior occasion. Would you agree that there is absolutely no way that Kaylee would have been able to open that gate?
Oh, there's no way she could open the gate to the from the backyard to the front yard. There's no way.
And as far as the date of that ladder incident, you have in the past testified that it was in the week before the gas can incident, haven't you?
Yes.
Okay. Today you say that that was the night of the 16th, but do you acknowledge that you've said it was the 17th or even subsequent dates during that week?
Yes. I mean, when I was looking back, early on I was asked about it, and I knew it was either the 16th or 17th. I knew it was in those first 2 days after I didn't see her anymore.
You said that you called George when you made that discovery.
Yes, I did.
Did you call George from the house phone?
I'm not sure if I used the house phone or my cell phone, but I did call George.
Okay. Well, those would have been your only 2 options, right? The house phone or the cell phone.
Correct.
And if George wasn't at the house, as a call to him would suggest, you would have only the option to use his cell phone.
Correct.
To reach him.
Correct.
Okay. It's not like there was a work phone where you could get him at his security job. You had to call him on his cell phone.
He had 2 phones. He had a work phone and his cell phone. And sometimes I did call him on his work phone if he didn't pick up on his cell phone, or he would call me, from either or, depending on, which phone he was using.
Do you recall if you left a message for him that day, or did he pick up when you called?
I know I spoke to him. I can't remember if I spoke to him after I had left a message or not, but I know that we had communicated.
You acknowledge as well that as it relates to dates in June of 2008, that you've already made other errors, specifically when you filled out your initial sworn statement, you indicated the last time you had seen Kaylee was...
Just a second. Response to outside the scope.
Your Honor, we're talking about, he, in direct examination, asked questions about specific dates. I'm attempting to get the witness to acknowledge that she has made errors on dates in June of 2008 in the past.
Overruled.
Ms. Anthony, you recall that your first sworn statement to law enforcement as to the date that you last saw Kaylee had an error, correct?
Yes, ma'am, I do. I'm aware of that.
You had indicated that the last time you saw her was actually a week prior to Father's Day.
Correct.
And it was the video of her with your dad
Yes,
that refreshed your recollection as to the accuracy of that date.
that's correct.
You said that you went to work and told some of the people at your office about the incident with you believing somebody was swimming in your pool.
Yes,
Okay. You also told them about the gas can incident that was reported to the police on June 24th, correct?
Outside scope.
I'm not going to ask her questions about that. I'm asking about what she is reporting to her coworkers, since there was a question about, did you tell them at work about certain things that happened in June of 2008?
Overruled.
yes,
Okay. Are you sure you were at work on June 16th of 2008?
yes, I know I was at work on June 16th, 2008.
Okay. Your time card reflects that you were at work on June 16th of 2008, does it not?
I would imagine it would, but I haven't reviewed that time card in 3 years.
May I approach the witness with 318 in evidence?
You may.
Have you located the entry for the week ending? Let me think. 20.
Yes,
Shows you were at work on June 16th of 2008.
yes, ma'am.
Okay. That's accurate?
Yes,
Are you sure you were at work on June 17th of 2008?
yes, without looking at this, I'm sure I worked June 17th.
Every day that week?
Yes, I had,
Through the 24th of June when the gas can incident was reported.
yes, I had just come off vacation. So yes, I was back to work.
Okay. That time card accurately reflects that June vacation, doesn't it?
Yes, it does.
Your daughter, Casey, was home between August 22nd of 2008 and October 14th of 2008, correct?
All right, goes to outside scope.
Sustained.
Did you have contact with your daughter, aside from what was on the videos that were done at the jail?
Outside scope, Your Honor.
Sustained.
You showed us photographs of Kaylee getting in and out of the pool. Did your daughter tell you that there was an accident involving the pool?
Objection, Judge, outside the scope.
Overruled.
No, ma'am.
In fact, she continued to assert to you after July 15th of 2008 that the child was kidnapped by a babysitter, correct?
That's correct.
Those are all the questions I have on the issues presented, Your Honor. Thank you.
Redirect.
May I approach the witness, Your Honor?
You may.
Mrs. Anthony, I'm showing you the photographs that Mr. Burdick just showed you. States RE, states RF, RG, RH, RI, RL, RK, and RJ. Now, first off, those are just photographs of tags, are they not? You can see some of the garment, can you?
Overruled.
That's true on all but one.
Okay. And are all of those garments pretty much knit type garments? Cotton material?
All but one.
Okay. Can you show me the one that is not cotton? Now that one that you showed me, that is of jean material, correct?
Like a cotton. There's pictures of jeans in the background, but that one's like a cotton.
And the shorts that Kaylee was found in are jean type material, correct?
They're cotton type material.
Okay. The knit material is material that is much stretchier. Would you agree to that?
Absolutely.
Okay. So, are Kaylee's clothing? Does Kaylee grow out of clothing that are of that rougher, thicker material a lot faster than they would of the knit material?
Yes.
And you also have kept lots of clothing from Kaylee that she has outgrown, have you not?
Oh, yes.
You haven't sold it all at yard sales?
No, most of her stuff we have kept.
Okay. And a lot of this would be kept in Casey's room?
We had 3 locations, depending on whether or not Lee was home. If he was living at the house, then we wouldn't use that closet. But when he moved out, we used that closet or Casey's closet because she really didn't have a closet. She had an armoire. And then the drawers in her dress in her armoire, and then the changing table was full of drawers.
So Kaylee's clothing that she had outgrown would have been kept throughout the house?
Correct.
And the jeans, the shorts that Kaylee was found in, you testified with Mr. Burdick that you hadn't seen it for several months, right?
I hadn't seen her wearing those for several months.
And the only occasion that you would see them is if you had the occasion to wash them, right?
Correct.
You don't, back in those days, you weren't deciding to, I haven't finished.
Sustain.
Were on those days, were in early 2008, was it a frequent custom of yours to just go looking for clothing that didn't fit Kaylee anymore?
There were specific times that I would go through Kaylee's drawers, like Christmas time. If she received a lot of gifts, you would tend to take out the ones that were smaller and then put the larger size in. Birthdays the same way, any holidays.
And would you do these, would you best characterize that as spring cleaning type deal?
Or if I was putting something on her and noticed it was too tight, I'd note that. Sometimes I would set it on her dresser or may even leave it in the drawer with the intention to go back and go through all the clothes to kind of see if I had time to go through and see what fit and what didn't fit.
And unless you were washing these clothing, you wouldn't see them on a regular basis. Would
That's
you?
correct.
And that's consistent with what you just said, what you testified to, that you hadn't seen those clothing in a long time, those shorts in a long time.
I would say so.
And I know that this is going to sound odd, but Kaylee was a child, right? Almost 3 years old?
You mean instead of it being a baby?
Yes. She was a regular toddler.
Yes.
Okay. And as to her being obedient or not, did you treat her and discipline her like as if she were in the military or anything like that?
No.
Okay. Were you overly strict with her?
No.
So she ran and played like any other toddler?
Depending on her surroundings.
And she was just your average, if not above average, toddler.
I felt she was above average.
Thank you. No further questions.
May the witness be excused? Any more questions from the state?
Just very briefly. Mrs. Anthony, the fabric in the shorts that you were talking about, they're pink cotton
Yes, ma'am.
shorts. Was that the same fabric as the shorts in the photograph? I believe it's 314. You can correct me if I'm wrong, but the one that we saw that you said was taken in 2007.
Yes, it's similar.
The sturdy cotton that has less give than a knit fabric.
Yes.
That's all I wanted to clarify.
Okay, may Mrs. Anthony stand down? Thank you, ma'am. You may stand down.
Thank you.
The defense may call their next witness.
Yes, Your Honor. If I could call Lee Anthony.
You solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God.
Yes, sir.
Thank you. So please.
You may.
Lee Anthony, Leeanthony.
Good morning, Mr. Anthony.
Good morning.
Mr. Anthony, did you at one time own the white Pontiac Sunfire?
Yes.
Okay. From what year to what year did you own that car?
Approximately 2000 until early 2005.
I'd like to show you some photographs. Your Honor, I'd like to publish to both the witness and the jury states Exhibit 47, 79, and 80.
You may publish.
Can you see that, sir?
No, you can't see.
Oh.
You want me to do it or you going to do it? I'll do it.
Thank you, Judge.
Yes, I can see it.
Is that the white Pontiac Sunfire that you once owned?
Yes, sir, it is.
Okay. I'd like to now show you photographs. States 79. Do you see that, sir?
Yes, I do.
Does that appear to be the trunk of your of the car you once owned?
Yes, it is. I recognize the amplifier in the back.
Okay. Give me a second. I'm trying to clear up the glare if I can.
For us to put them on for you. Just let them know which ones you want. They can find them.
Okay, can you see that now?
Much better.
Okay. Now, when you owned this car, was there a stain in the trunk of the car?
There were a few, yes.
Okay. Can you show with the illustrator, just kind of circle on the screen where these stains were?
Okay. I specifically remember there being 3. They were all outside of the...
Go ahead and mark on the...
Okay. They're all outside of the tire cover. There was one there, approximately. There was one higher up below the amplifier. And then there was a smaller one just kind of on the side over here.
And were they there when you purchased the car?
From everything I remember, yes. I remember seeing those numerous times throughout the time I owned it.
Did you have an occasion to stain the trunk of your car on any occasions? How long did you own it again? I'm sorry.
Almost 5 full years.
So in those 5 years, did you ever create any stains in the trunk?
I'm sure I may have, but I don't recall specifically making any of those 3, but I do remember seeing them. It was just normal to see those.
Okay, I'd like to show you another photograph. Is this a little better view of the trunk?
Yes.
Can you show us where...
Exhibit number states what?
States 80.
Thank you.
Apologize. Can you show us where on this photograph the stains were?
Sure. And then the other was off the picture.
Off the picture. Okay. And how long would you say those stains were there?
If not I don't know for sure. More often than not, longer than for the majority of the part that I owned them, if not the entire time I owned them.
Okay. Now, they don't come up too well on these photographs.
No, they don't.
Do
No, they don't.
But they were there when you would be able to see it. Is that correct? When you
Absolutely.
opened up the trunk?
Yes.
Okay. Is everyone? May I unpublish, Judge?
You may.
The jury's finished. Mr. Anthony, can you tell us when's the first time that you noticed that your sister was pregnant?
You may. Judge overruled.
Can you first tell us about the very first time you suspected that your sister was pregnant or noticed?
Yeah, it's hard to give an exact time, but it would have been early to mid 2008.
Now, this was during the time that you were living in the home.
Yes, I had not moved out at that point.
Okay. And describe to the ladies and gentlemen of the jury how that occurred.
How I saw Casey?
Yes, how you first saw Casey showing.
Okay. It would have been later at night. Our bedrooms are right next to the bathroom, so I was waiting for her to get out of the bathroom, and when I went in when she was coming out, I could see her, midsection, and it was showing. So at that time, it struck me as odd because I guess I just hadn't noticed it prior to that.
And what did you do with this information once you saw this? What did you?
Overruled.
I believe I made some kind of comment towards Casey that said, like, excuse me, what the hell is that? And she's kind of waved me off. And then the next time I would have seen my mom, probably in the next couple of days, I recall asking her, is Casey pregnant? Looks that way to me.
Not responsive narrative.
Sustained.
What happened next?
Objection. Relevance calls for hearsay.
Overruled at this point, but the question should not elicit a hearsay answer.
We're not offering this for the truth of the matter, Your Honor.
I don't know what's coming out, so approach the sidebar.
Yes, sir.
You may continue.
Now, Mr. Anthony, you were saying that the next day you had advised your mother that you thought Casey was pregnant, correct?
I confronted her with that within a day or two. Yes.
Okay. And then when's the next time you saw Casey being obviously showing?
This would definitely have been in the middle of 2008. She came and picked me up at the airport.
Now, Kaylee was born in 2006, right?
Oh, I'm sorry. Yeah, I'm sorry. I have the years wrong. No, she was born in 2005.
Oh, excuse me. So you're referring to 2005?
Yes, I apologize.
Okay. Did there come an occasion where you saw or you noticed this again to any greater? Did you see her showing more?
Absolutely. It was brutally honest at that point that she was pregnant.
Okay. And was it known in your family, or was it discussed in your family at all that she was pregnant?
Objection. Hearsay specific without specifying an individual in your family.
Your mother,
Sustained.
your mother and your father.
Objection. Compound question.
Sustained.
Was it discussed with your mother that at this point that Casey was pregnant?
Myself and my mother,
Yes.
prior to asking her a few months before, no.
Okay. And then after you talked to your mother about it and you confronted her, was there about a month later that you saw Casey again? Did she pick you up at the airport or anything like that?
Assumes a fact, not an evidence that he confronted anybody.
Sustained. Rephrase your question.
Was there an occasion where your sister picked you up at the airport?
Yes, there was.
Okay. And how was she showing when she picked you up at the airport?
Far enough out to where I know she just wasn't putting on weight.
I'm sorry?
Far enough out to where I know she wasn't just putting on weight.
Okay. Are you saying that she obviously looked more pregnant?
Yes.
Okay. And was this how long after you had already confronted your mother?
Objection. Assumes a fact, not an evidence.
Sustained.
Move to strike counsel's comment.
I'm
Let's,
asking.
let's continue. Next question.
Yes, sir. Can you give us a time frame from when she picked you up at the airport to when you had confronted your mother about Casey's pregnancy?
Objection. Assumes same fact, not an evidence. I've objected twice.
Sustained.
Did you have any discussions with your mother or your father about Casey's pregnancy when she picked you up at the airport?
No, I did not.
During the time period between the time you confronted your mother and the time that you had picked her up at the airport?
Wait. Let him finish answering the question. Sit down. Mr. Anthony, do not answer a question until I tell you can answer the question. Ask your question, Mr. Baez.
Yes, sir. Were there any discussions between the time that you confronted your mother and the time that that Casey picked you up at the airport that had anything to do with Casey being pregnant?
Any objections to that question?
As rephrased, no, sir.
You may answer.
Okay. From the time I confronted her with that until that time, we never spoke about it again. No.
Okay. And when you say again, what does that mean?
Until just a few days before Kaylee was born.
Okay. And are you saying that the very first time there was any discussion about Casey's pregnancy was, other than the time you confronted your mother, was just a few days before Kaylee was born?
That's the only time it was acknowledged to me that that was indeed the situation, yes.
And when Kaylee was born, did you go to the hospital to see your sister?
Regrettably, no, I did not.
And why didn't you go?
I was a little hurt. Just didn't want to be there.
What? Who were you angry with?
Relevance.
Sustain.
Why were you hurt?
Relevance.
Sustain.
Can you explain to us the reasoning behind why your actions?
Relevance.
Sustain.
Your Honor, may I approach so I can explain?
Yes, you may.
No, thank you.
You may proceed. Objection overruled.
Thank you. Mr. Anthony, can you tell us why you were angry and who you were angry with as to why you didn't go and see Kaylee and Casey at the hospital?
I'm sorry. I was very angry at my mom, and I was also angry at my sister. I mean, I was just angry at everyone in general that they didn't want to include me, and didn't find it important enough to tell me, especially after I'd already asked. So I was very hurt, and I didn't want to. I don't think I wanted to believe it, you know. I'm sorry.
I'm sorry, what do you mean they didn't want to include you?
Interpretation of someone else's.
Sustain.
Were you angry because they hid the pregnancy from you?
Asked and answered and leading.
Sustain as to leading.
Do you need a moment, sir?
I'm okay.
Why were you angry?
Asked and answered.
Sustain.
Are there other reasons why you were angry?
Objection. Asked and answered.
Overruled as to that question.
Were there other reasons why you were angry?
Question, Counselor, yes or no answer, sir. Other than the answer that you've already given, were there other reasons? Yes or no?
No.
I can have just a moment, Judge.
You may.
I have no further questions. Thank you, Mr. Anthony.
Okay, time is about 5 minutes to the hour of noon. We're going to recess for lunch. I'm going to ask that you not discuss this case among yourselves, nor with anyone else. Any additional instructions on behalf of the state
No, sir.
or the defense? We'll be in recess to 1:30. Okay, let's return Mr. Anthony to the witness stand. Mr. Lee Anthony, and once we get him in, we'll return to jury. Stay recognized, presence of jury.
Yes, sir.
Defense. Members of the jury, did you heed my previous admonitions during your recess? All right. Mr. Ashton, you may begin your cross-examination, sir.
Thank you. Could we begin by publishing State's Exhibit 80 in evidence?
You may.
Mr. Anthony, you see the photograph, State's Exhibit 80 in front of you.
Yes, sir, I do.
This is the photograph that you were discussing with Mr. Bias. Is that correct?
Yes, it is.
I believe you indicated that there were stains pre-existent in this trunk from approximately this area, and then one that's off the picture. Is that correct?
That is correct, yes.
This large stained area on the spare tire cover, about the size of a basketball, that was not in the car when you owned it, was it?
I don't recognize that one as something I'm familiar with now.
And when you owned the car, it didn't have a stench, did it?
Did it have what up, sorry?
Didn't have a stench, didn't stink?
No.
Overruled.
I'm going to unpublish now, Judge, if I may. Now, Mr. Anthony, in preparation for this trial, were you requested to meet with a member of the prosecution team to go over your...
Beyond the scope.
It goes to Bias, Your Honor.
Overruled.
To meet with a member of the prosecution team to go over your testimony to prepare you for what questions we would ask you on direct?
I believe so, yes.
And you refused to do that, did you not?
Yes, I did.
But Mr. Baez requested a meeting with you this week to prepare for this testimony, did he not?
To my knowledge, when he asked me, it was not to prepare for this testimony, and I had previously refused to meet with him prior to this week also. I had reached out to him prior to this week, and then we followed that up with a meeting earlier this week. Yes, sir.
So you reached out to Mr. Baez?
Last week I did, yes, sir.
For what purpose?
Judge, I'm going to object and ask that the instruction be read as requested by Mr. Ashton.
Your Honor, there's no implication of impropriety by counsel.
Overruled at this point. Let's continue.
The question was, why did you, after refusing to meet with anyone on the prosecution team, reach out to Mr. Baez?
While I was in court, the last time that I was in court, prior to me getting called onto the stand, during a break, I sat in with my folks, and there was a discussion, or I was present during a discussion, where information came out that I thought it was important for Jose specifically to be made aware of. So I then took it upon myself a few days later, as I had no indication that he was going to be made aware of. I took it upon myself to do that.
And was this on the subjects that you have discussed under examination here today?
No, sir. None of those items were discussed now.
All right. Now, in reference to your discovery of your sister's pregnancy, did I understand you to say on direct that you did have a conversation with Casey when you discovered what you refer to as the bump?
If I said bump, I apologize.
I didn't mean offense by that, just the evidence that you thought.
I more or less made a remark. I don't know if I was even expecting a response because I didn't really get one. I just said something of kind of what the hell is that in passing.
Do you recall having your deposition taken on July the 30th of 2009, almost 2 years ago, in reference to this case?
Yes, sir, I do.
And you were under oath at the time, were you not?
Yes, I was.
And you were questioned by Mr. George, is that correct?
Yes, I was.
And Mr. Baez was present along with other counsel, correct?
Yes, sir, he was.
This is at page 30. Let me start at 30. Page 31, line 6. Can we show that to the witness? Let me publish to the witness. All right. Can you show about line 6 to line 15? Do you recall that series of questions and answers about the event of your seeing the bump or the bulge?
I recall this testimony, yes.
And in that testimony, you were asked whether you, I believe the word was, called her out on it, that being the bump.
Right.
I'm going to object to proper impeachment. The witness has already testified it has refreshed his recollection.
This is impeachment, Judge. This is not
Overruled.
And in that event, you said, when asked if you called her out on it, you said, it wasn't really my place. If I did, not directly to her. Do you recall saying that?
It's here, so yes.
So in July of 2009, you indicated that you did not say anything directly to her about it, but your testimony here today was that you did.
Well, sir, I also did not call her out on it when she showed up at the airport to pick me up, and it was quite obvious at that point as well. I don't know exactly which scenario this one's referring to. Maybe if you refer to a
Can we show the witness
date or time or something.
Can we show the witness page 30, and we'll let you read the whole context?
Thank you. I appreciate it.
No problem.
Before that concludes, I would ask that counsel read his entire answer, not just half of it.
Read the entire answer.
Your Honor, if I may, the remainder of the answer does not deal with this subject matter. It deals with a separate subject matter.
Yes, sir.
Just a second. You can do it on redirect.
Have you read the context?
I didn't really have a starting point. I just kind of started in the middle. So would you like me to read that entire page?
Just to yourself, just to
thank you.
establish the context of whether this was the first occasion you saw the bulge or the
Yes, sir, thank
airport occasion. This was a reference to the first occasion, wasn't it?
I've read that entire page.
What you were referring to the first time that you noticed, correct?
I do not recall. There's nothing in here that makes me think that that was unique to the first time or the incident at the airport. There's nothing specific asking me that.
Now, when your parents learned of the pregnancy, they were very excited, weren't they?
Couldn't tell you. They didn't admit it to me.
Well, is it your testimony that from the time that you learned it till the date of Kaylee's birth, there was no activity in the home indicative of preparations for the birth of a child?
I'm not saying that at all. Actually, that was one of the reasons why I was so angry. And I decided not to go see my sister in the hospital, was because I was not included on it. And when I did ask about it one time early on, it was denied to me and I was told to let it go. So that's what I did.
Your parents were over the top about this, weren't they?
Especially afterwards, absolutely, yes, sir.
No, even before. They were over the top. You've described them as over the top. Isn't that right?
My parents are very over the top. Prior to, my sisters actually having Kaylee, to be honest with you, I didn't really pay it a lot of attention. It was something that I was told to let go and not address, and I was frankly quite angry that I wasn't included in it, so a little easier to block it out at that time.
So you've said, Mr. Anthony. Can we have page 35 of the deposition, please? Could you just read that whole page, Mr. Anthony, for me?
Yes, sir.
To yourself.
Sorry, I'm just reading my last
Sure.
paragraph because I kind of ramble in there, so it's hard to get my point. Okay.
In that paragraph, you discuss the period of her pregnancy before Kaylee was born, correct?
Is that 14 through 23?
Yeah, the whole page.
The whole page? Yes, sir, yes.
And in that, you indicate that that you felt your role was just to be there in the background to support, not really be over the top, because, of course, my parents wanted to be the ones to go over the top. They're grandparents, but just be there. That correctly reflects your parents' response to the imminent birth of their granddaughter, does it not?
In regards to them wanting to be over the top?
Yes, that is a description of their emotion, how they felt about it, their excitement. That's what you meant to convey by that, didn't you?
Speculation.
Ask him what he meant to convey by the answer.
You can ask that question, yes or no.
I believe that was the impression that I was under. I mean, I wasn't asked to be involved with things, so all I could deduce from that is my role was to sit back, be non-judgmental, as I referenced in there, be in the background, and they would take care of it. They would do whatever's necessary, and their nature would be to be over the top.
What preparations in the house did they make for the imminent birth of Kaylee?
I believe they got her a crib.
Didn't they redecorate?
What else? I don't remember.
Didn't they redecorate an entire room? What had formerly been a family computer room that they completely redecorated for Kaylee?
To my knowledge, yes. I wasn't personally involved in it, but to my knowledge, yes.
But you saw it, correct?
After the fact, yes, sir.
Right. And it's, your parents, particularly your mother, never does anything halfway. It was decorated to the nines, wasn't it?
From everything that I got to see eventually, absolutely, yes, sir, it was.
And that was in preparation for Kaylee's arrival.
I imagine during preparation it was like that. If she would do everything she could, yes, sir.
Well, you were there during the period of time leading up to Kaylee's birth, weren't you?
I lived there. I lived in the room right next door, actually.
And you know that your mother went nuts decorating this room for the birth of her first grandchild. Winnie the Pooh everywhere.
I know there was Winnie the Pooh everywhere. Again, I never walked in the room. I never went into the room until a little bit after the fact that after she was born. But I could imagine that she did that ahead of time, absolutely.
And your mother and your sister went shopping and bought all kinds of stuff in anticipation of Kaylee's birth.
I'm sure they did.
And they had a party, didn't they?
If they did, I wasn't invited.
Should they have a baby shower?
If they did, I wasn't invited.
Were you aware of them having a baby shower?
Yes, I believe so. It was in maybe June or so.
And they invited their friends? They invited Casey's friends? Did they invite Mallory?
I don't believe so.
You believe so?
I said I don't believe so.
But you know that they had a party.
I wasn't invited, so if whatever did transpire, I have no knowledge of it.
Well, where were you when the party occurred? It happened. Let me rephrase. It happened at the house, correct?
I would imagine.
Yeah. Well, I mean, you saw the aftermath. You saw all the presents and all the stuff that people got for Kaylee. It was at the house, right?
I didn't put any thought into it. I didn't ask to see presents, and I didn't go out of my way to do so. It was something, sir, that I was not involved in. It was something, sir, that was, I felt for a while, that was either hidden from me or something that I was not being made a part of. So I'm not going to go out of my way to invite myself or to know everything that's going on if I'm led to believe that I shouldn't be involved with it. So if that hopefully answers your question on why I wasn't an attentive potential uncle, I wish I was, but I was not.
But your parents weren't hiding this fact from their friends and loved ones. They invited them to a party.
Objection, Judge. This witness's knowledge of what his parents would do with their friends.
Sustained.
During this deposition, Mr. Anthony, we discussed the period of time leading up to the birth of your niece, and we discussed, in fact, whether you were present when she was born. Is that correct? Recall that?
I don't recall if we did, as far as me being present or not.
Okay. Page 36, just for the witness, line, let me just make sure this is only published for the witness. Yes. Line 22 and to the end of the page, just highlight that for the witness. You recall that question and answer?
I see the portion of my answer, yes, sir, and I recall the question.
Did you cry during that portion of this deposition, Mr. Anthony? To your recollection?
Don't recall if I did. I don't think so.
What was different 2 hours ago in this courtroom about that question that caused such raw emotion today, which was not present 2 years ago when you were asked the same thing?
There was other things that were asked in my deposition, specifically if I believed Kaylee was
Objection, Your Honor, non-responsive, move to strike. The question, Mr. Anthony, is this.
Yes, sir.
What was different about the question being asked of you?
I think we need to hear what the answer is.
I sustain objection to the question.
Question before you, Mr. Anthony, is this. What was different about the way, the emotion with which you answered that question 2 hours ago? It was different than the emotion that you did not display when asked the same question 2 years ago.
2 years ago, I did not 100% hold the belief that Kaylee was dead at this very moment, and 2 hours ago. And during that 2 year span, I've come to the place where I believe that she is. And my emotions are elicited from those facts that I have regrets, and I wish I could have been there a lot more than I was.
Mr. Anthony, you attended and spoke at a memorial service for Kaylee in January of 2009, 6 months before this deposition was taken, didn't you?
Yes, sir, I did.
No further questions.
Redirect us to those issues.
Mr. Anthony, you were asked about. Can I see that photograph? You were asked about a stain somewhere in this vicinity, the size of a basketball. May I publish this, Your Honor, to both the jury and
Yes, what's the exhibit number?
80.
States Exhibit 80. You may publish.
Yes, I was asked about that.
Do you see a basketball-sized stain there, or I mean, do
Photograph speaks for itself.
Overruled.
you see any basketball-sized stain there at all?
I see a few stains. Nothing necessarily that's the size of a basketball, no.
Do you see white powder of some sort?
The photograph speaks for itself. The witness has no basis to answer that question.
Overruled.
I do, and that's not what I would even reference necessarily as a stain that I was referring to. A white powder is a lot different than a stain, I would think.
Point to me where you see a stain in that area where Mr. Ashton was questioning you. If you see one.
In this section, I do not. It's very hard to see from this photo, but there is a stain here, and there's a stain here. There's also things that are circling right here at B. There looks like a different color, maybe powder or some kind of substance. I don't know exactly what that is. But the stains I was referring to were darker in nature, almost like I apologize, I'm colorblind, so my interpretation of them might be a little different, but more like a red or like a black, sort of just a darker, deeper color.
Did you see your mother use a entire bottle of Febreze in the trunk of this car?
Objection. Exceeds the scope of cross.
Overruled.
Never.
Okay. Did you see law enforcement spray the entire trunk with a Blue Star?
I don't even know what that is, and no.
Okay. Now, Mr. Ashton asked you about whether you had met with myself in reference to your testimony. Did you meet with the defense any time prior to trial? Let me rephrase that. Let me narrow that down a bit.
Okay.
Did you meet with the defense prior to you testifying for the state of Florida against your sister?
No, sir, I did not.
Okay. Did you advise us of any testimony you intended to give for the state of Florida against your sister?
No, sir.
Okay. Did you testify truthfully when you testified for the state of Florida?
Sustained.
Can I bring up page 31?
What are we publishing?
The question and answer asked by during his deposition.
Was not offered or published by the state of Florida.
I'd like to question the witness about it, Your Honor.
You can question him, but show it to the witness and the witness alone. Go ahead.
Yes, sir. Page 31.
What page?
I'm double checking where. Can you go to 30? I'm sorry.
Page what?
30. I'm just double checking. I want to follow up on a question. 31, I'm sorry. 31. You were asked, can you review lines 12 through 14?
I've read 12 through 14.
Okay. And you were asked during cross-examination, and the first sentence was read into evidence. Can you read the second sentence?
The second sentence says, I think if I did not to her directly.
Or?
Third sentence is, or I would have said something to my mom or to a friend of mine, you know.
And that's what you were referring to when you testified about telling your mother?
I'm sorry, could you repeat the question?
That's what you were referring to when you testified, that when you first told your mother about
Or
Casey's
first
pregnancy.
asked her about it, yes, sir.
Okay. So what you said in the deposition is what you testified to.
Misstating what's in the record, not what he said.
It's not. The witness can answer if it's true or not.
Witness can't change the answer.
Folks, if you want to read the answer in the deposition, you can read it. It will speak for itself. So if you want to read the entire answer, read the answer.
That we just did that, Judge.
Okay.
That's fine. I'll move
It
on.
speaks for itself.
Yes, sir. And, sir, when you testified under cross-examination, you said that you were told to let it go. Who told you to let it go?
My mom told me to let it go.
And that's referring to your inquiries about Casey's pregnancy.
My inquiry, yes.
And can I have page 33? Lines 13 through 18. Page 33, lines 13 through 18, if you can bring them up a bit. I'd like for you to look this over, if you can, Mr. Anthony.
I've read it.
Now, during cross-examination, Mr. Ashton suggested to you that that your parents were over the top and ecstatic. But that's not necessarily what.
Objection, leading. Overruled. He hasn't finished the question. Let him finish asking the question.
Is
Mr.
that
Anthony, before you answer the question, wait for me to tell you whether or not you can answer the question. You may ask your question, Mr. Baez.
Mr. Ashton mentioned that your parents were over the top with happiness prior to Kaylee being born. Is that what you testified to in your deposition?
You may ask the question, Mr. Anthony.
I believe it's to the extent of that in my deposition, yes.
Are there any other opinions you gave about your mother not being happy or not thrilled?
Yes. I gave an opinion that was my impression or thoughts that she was not thrilled that Casey would have a baby out of wedlock.
And the baby shower that was had for Kaylee, that actually occurred after Kaylee was born, did it not?
Sustain, rephrase the question.
Did Kaylee's baby shower occur after she was born, since everyone didn't know she was pregnant?
Objection, assumes the fact, not in evidence, move to strike.
I'll rephrase the question.
Sustain, rephrase your question.
Did Kaylee's baby shower occur after Kaylee was born?
I don't recall. For sure, I don't recall. I'm sorry.
Okay. You were asked why you didn't cry during the deposition.
Yes, sir.
Is sitting here today much different than sitting in the state attorney's office 2 years ago?
Meeting.
Overruled.
Absolutely.
And can you share with the ladies and gentlemen of the jury why?
want to be here. I don't want, my sister to be here, my parents to be here, and I'm also emotionally and all that stuff in a much different place, than I was a couple of years ago. And this is obviously just very, very emotionally draining and very difficult.
Mr. Ashton asked you about giving a speech at Kaylee's memorial prior to your deposition. And you testified about not, at your deposition, not believing Kaylee was dead. Is that correct?
I was not willing to write it off at that point in time. I didn't want to believe it, and I couldn't believe it at that time.
So you were able, after having a funeral for your niece, to block her death out of your emotions for approximately 6 months?
Objection, leading.
Sustain.
Were you able to block that emotion out of your, compartmentalize it?
Same objection, same question.
Sustain.
What were you able to do in regards to the death of your niece emotionally for 6 months?
I don't know the exact time frame. I don't even know when I really came to the belief that I have now that she is no longer with us. I could still tell you, even with that belief, if there's someone that looked familiar to her today, it would turn my head and it would make me look twice or 3 times or 100 times. I don't know when that really changed for me. I know last year was particularly hard for me around Kaylee's birthday and my birthday. But during the time of the deposition specifically, and they had even asked me at one point if I believed that she was dead, and I remember it being a big joke to some people that I didn't want to believe it or couldn't believe it. At the time, I didn't believe it, I couldn't believe it, and right now I do. So I have a very, very tough time with that.
Who was it a joke to?
Objection. Relevance.
Sustain.
I have no further questions.
Recross.
Mr. Anthony, you remember when you testified for the state of Florida? The state of Florida, remember?
July 2009, I think you referenced it earlier. Yes,
No.
sir.
When you testified for the state of Florida, as Mr. Bias pointed to.
Yes, sir. I apologize. Yes, sir.
How many times did Mr. George have to step up to you and show you your deposition to refresh your recollection about?
Objection, Judge. The record speaks for itself.
Goes to Bias, Your Honor.
And relevance.
Overruled.
Probably as many times as I've been showed something here today by yourself or Mr. Baez.
No.
A handful of times, 2-3 times. I don't recall. I wasn't counting.
In your direct examination by Mr. Baez, did he need to refresh your recollection at all? I don't.
He referenced me. He did reference me to a few pages that he asked me to read. I don't believe he qualified anything to say that he needed to refresh my recollection. No. Sir.
During his initial direct examination, your testimony is you recall him having to refresh your recollection.
I don't believe so.
No, your recollection was just fine for the questions that Mr. Baez asked you in his initial direct, weren't they?
On all these, I believe they were, yeah.
But when Mr. George attempted to question you on direct examination, your memory was more troublesome.
It's hard to remember something you did 2 years ago. Absolutely.
Could I have, just for myself and the witness, page 31 of the deposition? Page 17, line 17 through 24. I'm sorry, line 15 through 24, please. you were asked the question at the deposition, did you say anything to your mom? Say, hey, Casey's looking. And your answer was probably. At a minimum, probably of passing. I don't think I ever made a big enough deal because, if my mom didn't make it a big deal or if she shrugged me off or whatever reason.
This is not impeachment.
It is impeachment, Your Honor.
Overruled.
If she shrugged me off for whatever reason, then either I was wrong or my sister was just getting fat, or for whatever reason, they don't really want me involved in it. Whatever, either way. So at deposition, your recollection was at best that you probably spoke to your mother.
That's what this says here is probably. I do remember speaking to my mother, but that says probably.
So your recollection is better today than in July of 2009 at the deposition?
If you assume that because I didn't say the word probably today, sure.
Well, you will admit that your recitation seems to be somewhat not a big deal. Don't really remember it very well, correct?
Argumentative.
Sustain this to the last question.
You said probably at minimum of passing. I don't think I ever made a big deal.
Excuse me, Mr. Ashton. My objection is this has been asked and answered. He's read this already.
Sustain.
If we could go to page 33, please. Lines 1 through 8. Read that, please.
To myself?
Yes, to yourself.
Thank you.
And if you need to see the page before, I'll be happy to show it to you. But
Thank you.
This is outside the scope of redirect, Your Honor.
Mr. Ashton.
yes, Judge, it's in reference to when the baby shower and the preparations were.
Overruled.
In that, you indicate, does that refresh your recollection about that the baby shower was in the months preceding Kaylee's birth?
Yes.
No further questions.
Mr. Baez, any additional questions? Remember when you... Okay, Mr. Anthony, you may stand down, sir.
Yes, sir.
Mr. Members of the jury, do you hear that noise? There is a hawk that from time to time will purchase himself out there on the ledge after lunch, after he has had his or her lunch.
Judge, our next witness is in the restroom. Just needs a moment.
Okay. Well, why don't we do this? While you're waiting on your witness, this would be a good time to take a 15-minute recess to a quarter till. Did the dessert lady show up today? Okay. You're welcome. Okay, you may be seated. Okay, let the record reflect that the defendant is present along with counsel for the defendant, assistant state attorneys, both sides ready to proceed.
Yes, sir.
All right, let's return to jury. You got your next witness on tap?
Yes, sir. So from what we had discussed earlier, I think that's going to be an issue. Just letting you know.
Tell your colleagues. Okay. Okay, state recognized presence of jury, defense,
Yes, sir.
and members of the jury. Did you heed all of my previous admonitions during the recess? Case, defense may call the next witness.
Defense calls Cindy Anthony.
Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God? Thank you.
Cynthia Anthony, Cynthia, Anthony, Anthony.
You may proceed.
Mrs. Anthony, when was Kaylee's baby shower?
It was postponed because of her birth. I believe it was around the 27th of August.
Okay. Was it before or after Kaylee was born?
Kaylee was supposed to be born in September. We had the shower slated for August the 13th, and Kaylee was born on the 9th, so I had to switch the invitations. I had to contact everybody and change the date of the baby shower.
So just so we're clear, though, but was it the baby shower held before Kaylee was born or after Kaylee was born?
I just stated it was after Kaylee was born because Kaylee came a month early.
I understand. I just wanted to be clear about that. Your Honor, may I approach the witness?
You may.
What is that a photograph of? Defense, sorry, excuse me. I'm showing you Defense Exhibit ER.
Your Honor, Mr. Bias has shown these series of photographs to me, and I do have an objection to all of them on relevance.
Pardon?
Mr. Bias has shown these photographs to me, and I have an objection to the series of them on grounds of relevance.
Okay, we'll wait till you get it off.
Yes, sir.
Well, I object to a description of the photograph prior to its admission.
Okay. All you need to do is establish that she recognizes it and whether or not it adequately and accurately describes the subject matter therein. And
Yes, sir.
then you can offer them, and we'll see if they object.
Do you recognize the photograph, Mrs. Anthony?
Yes.
Is it a true and accurate depiction of what it actually is?
Yes.
At this time, Your Honor, I would move exhibit, I believe it was ER, into evidence.
It's not. Oh, I'm sorry, sir.
That I would have an objection at this point, as indicated on relevance grounds.
You want to approach the sidebar, Mr. Baez?
Yes, sir. May I approach the witness, Your Honor?
Okay, the objection as to the last exhibit will be sustained. You may continue with your direct examination.
Yes, sir. May I approach the witness?
Yes, sir.
I'd like to show you again, Mrs. Anthony, defense exhibit A. You recognize that photograph?
Yes.
And is it a photograph that was taken at your brother's wedding?
Yes.
Okay. And is it a photograph of you and your daughter?
Yes.
Okay. And at the time that that photograph was taken, did you believe that your daughter was pregnant?
No, I did not.
Did anyone advise you that your daughter was pregnant?
Exception to the hearsay rule, Mr. Baez?
No, withdraw the question.
Okay.
Judge, at this time, I would move into evidence defense exhibit A.
State.
Same objection as previously lodged on relevance.
Objection to be overruled. That would be admitted.
Defense A will become defense number 56.
Mrs. Anthony, who attended the baby shower?
Casey's grandmothers, her aunts, some of my friends, Jesse Grunn's mother, neighbors.
Was Lee present?
No, none of the guys were present.
I have no further questions.
You may. Cross-examination? No. The witness may stand down.
Thank you.
The defense may call the next witness.
Ryan Eberlin.
Stand here and raise your right hand and answer out loud.
Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thanks, Lisa.
Ryan Eberlin, last name Eberlin.
I always say it wrong. I said Eberlin. I'm sorry.
It's all right.
You are a member of the Orange County Sheriff's Department.
Yes, sir.
Were you so employed in July of 2008?
Yes, sir.
on or about July the 15th, sir, were you dispatched to a residence on Hope Springs Drive?
Yes, sir.
You know who lived there?
The Anthony family.
Had you ever had any contact with the Anthony family prior to that time?
No, sir.
Sir, when you arrived, did you participate in an overall just kind of controlling the scene and what's going on and asking questions?
Yes, sir.
And at that point in time, sir, did you observe a white Pontiac Firebird automobile?
I did, sir.
Did you notice any particular odor about that car when you were looking at it?
No, sir.
In addition, sir, after you had some interview there, did you have occasion to put handcuffs on Casey Anthony?
Yes, I did, sir.
And were you subsequently instructed by Sergeant Hosey to remove the handcuffs?
Yes, sir.
Thank you. No further questions.
Cross-examination.
Thank you. Deputy, you were the junior deputy on the scene, so to speak.
Yes, ma'am.
Okay. And Sergeant Hosey was there as well?
Yes, ma'am.
The handcuffing of Ms. Anthony was for 2 or 3 minutes?
Yes, ma'am, approximately.
Okay. And after that, she was immediately released and went back into her house and was free to go about her business, correct?
Yes, ma'am.
Why was Ms. Anthony handcuffed?
While Casey was inside the house, her mother, Cindy, had approached me while I was outside and informed me that Casey had stolen her.
Hearsay?
Open the door, Your Honor.
Still hearsay.
Exception to the hearsay rule.
Your Honor, the complainant formed the basis for probable cause for this individual.
That should be sidebar.
Okay. Okay. Okay, members of the jury, there's going to be a brief legal matter we need to take up outside of your presence. We will get back with you as quickly as possible. Maybe seated. Okay, Ms. Burdick, you may continue.
All right, Deputy, can you tell the court why you put handcuffs on Ms. Anthony?
Cindy Anthony had approached me while Casey was inside her residence while I was on scene and came out with receipts stating that Casey had stolen her credit card and made fraudulent purchase with that credit card. And she wanted to press charges for or against Casey. I then went inside the house, detained Casey, and brought her into my car and was going to continue the investigation of the fraudulent use for credit cards. At that time, when I placed her in the car, that's when Sergeant Hosey had told me, we're not concerned about the fraudulent use of the credit card at this time, only the kidnapping that we were investigating, and informed me to take her out of cuffs, which I did, and she went inside.
All right. Now, as it relates to the timeline of events, this happened after Ms. Anthony did her written statement for you at 1 in the morning, correct?
To the best of my recollection, yes.
Okay. But before at the time, Corporal Melich arrived at 4 a.m.
Yes.
Okay. That's all we have for the proffer.
Okay, argument. Mr. Mason and then the state.
I don't think there's anything else to add to that, Your Honor. External 403 and or the instruction to the jury that she's not on trial for any of this.
I'm sorry, Mr. Mason, can you repeat that last part?
What did you not hear? All of it?
Repeat it again, Mr. Mason.
I'm having to read you.
Not on trial for any other.
Not on trial for any of those allegations, whether it's credit card or car or otherwise.
Okay. The defense raised the issue of the handcuffs being placed on Miss Anthony, and then elicited questions that the officer removed the handcuffs without any particular explanation as to the reasons why, which opens the door for this particular testimony. The court will fashion a jury instruction to deal with this. Just a second. Okay, this is the instruction that I propose to give. The evidence you're about to hear concerning the reason for the handcuffing of Miss Casey Anthony is solely to explain why the deputy did what he did, and is not to be considered for any other purpose. The defendant is not on trial for those acts, and you should not consider it for any purposes except to explain why the deputy did what he did. Any additions, deletions from that particular instruction? State.
No, Your Honor.
Okay, this is the final version. The evidence which you are about to hear concerning the reasons Miss Casey Anthony, the defendant, was handcuffed is to solely explain the reasons why the deputy took those actions, and is not for any other purpose. The defendant is not on trial for those acts, and you should not consider it for any other purpose except to explain why the deputy handcuff the defendant. Okay, let's return to jury. Stay recognized, President of the jury.
Yes, Your Honor.
The defense. Ladies and gentlemen, the evidence which you are about to hear concerning the reasons Ms. Casey Anthony, the defendant, was handcuffed is solely to explain the reasons why the deputy took those actions and is not for any other purpose. The defendant is not on trial for those acts, and you should not consider it for any other purpose except to explain why the deputy handcuffed the defendant. You may proceed.
Thank you. Deputy, you had indicated Ms. Anthony was handcuffed for a very brief period of time, correct?
Yes, ma'am.
Okay. Was that done after she had provided the written statement that you countersigned for her?
Yes.
Okay. After that occurred, Mrs. Anthony, Cindy Anthony, came to you when you were outside and indicated that she wanted to press charges against her daughter Casey for the fraudulent use of her credit card, correct?
Overruled.
Yes.
Okay. And in order to further that investigation, you went into the house, handcuffed Ms. Anthony briefly, at which point in time your supervisor, Sergeant Hosey, told you that he wanted the handcuffs off.
Yes, ma'am.
Okay. At that point, Ms. Anthony was free to go back into the house while the investigation continued into the alleged kidnapping of her daughter, Kaylee, correct?
Yes, ma'am.
Corporal Melich showed up at least an hour or more after that, correct?
I don't recall the gap in time, but
Was it after?
yes, the detective showed up after that.
All right. And he was not present for this exchange between you and Cindy Anthony, correct?
No, ma'am.
Okay. Or you and Casey Anthony, for that matter.
Correct. No.
Okay. And then once Corporal Melich arrived, you were not involved in any way, shape, or form in the taking of additional statements from Ms. Anthony, either at her residence at 4 o'clock or so that morning, correct?
Yes, ma'am.
And you were not involved in taking any statements from her on July 16th at Universal Studios, correct?
Correct.
Thank you. That's all I have, Your Honor.
Redirect.
No further questions, Your Honor.
May the deputy be excused.
Yes.
Thank you, deputy. You may be excused, sir. The defense may call their next witness.
Corporal Eric Edwards.
Okay, ladies and gentlemen of the jury, there is another legal matter that we're going to need to take up outside of your presence. I will get back with you as soon as possible. Please do not discuss this case among yourselves nor with anyone else. Okay, let the record reflect that the jury is outside of the courtroom. Mr. Mason, you may proceed with the proffer.
Thank you, Mr. Edwards. I ask you, sir, if you knew Linda Tenelli.
I met her through the investigation, yes, sir.
And who did you learn, what did you learn was her involvement initially in this case before you did further things with her?
I'm sorry, sir, I can't hear you very well.
What did you learn about her first as far as this case is concerned?
She was brought to my attention by an individual by the name of Lori Cree that was a volunteer for Texas EquiSearch. And I don't remember the date off the top of my head, but at any rate, I want to say it was about the time, somewhere in the December time frame when we visited Texas EquiSearch, and while we were out there, I received a phone call, I want to say, from Lori Cree, and that's when she brought Linda Tenelli to my attention, I believe the first time. I could be wrong on that date. But at any rate, from that conversation with Lori Cree, Linda Tenelli was a volunteer at the Kid Finders tent and spent a great deal of time there assisting with the Kid Finders and the Anthonys, or George Anthony, anyway. Does that answer your question?
Yeah. Did she coordinate one of the tables in the overall, the volunteers searching for Kaylee?
I know that based on the communication we had with her, because John Allen and I had interviewed her shortly after returning from Texas, I think she was in charge of maintaining the volunteer sheet or something of that nature.
Did you have occasion to discuss with her, sir, any issues regarding duct tape?
I did. I showed her a photograph of a image that had been provided by one of the local media outlets, I'm not sure which, and because that, I believe, now that you say that, I believe that's what Lori Cree had said, that Linda may have even brought to her attention, that she recalled that Mr. Anthony brought some duct tape to the Kid Finders tent at one point, and I'm not sure that was one of the reasons that we interviewed Ms. Tenelli.
Did you show the picture of the duct tape, in fact, to Ms. Tenelli?
I'm sorry?
Did you show the picture, the photo of the duct tape?
I showed I can't recall if it was a video and we captured one image of that, or if it was a download of one photograph. I can't recall off the top of my head. But I know we did show her it was kind of a fuzzy image of one of Kaylee's missing pictures with the duct tape on it at a tent, is my recollection.
Yeah. And did she identify seeing the duct tape with George? Mr. Anthony, excuse me?
She, and I'm going off memory here, she didn't specifically say that's the tape that I can recall. She just described a very strong tape for whatever reason. And Mr. Mason, without looking at that transcript again, I can't recall everything off the top of my head. But I would have brought to someone's attention, or I think it would have been more of a deal if she said, no, that's definitely the tape, because it's very, you can identify it due to the writing or the markings on it. So that doesn't stand out in my mind.
After the remains were found, did you, in your official capacity, contact Miss Linda Tenelli?
Do you have something that could refresh my memory? Because I know there was another time when John Allen and I had driven out and met her and contacted her again because of some correspondence or communication she had with the Anthonys.
Do you remember, sir, going to her home in around March of 2009?
Yes, sir.
And did you at that place and time discuss with her placing eavesdropping equipment in her house, like a bug on a lamp in the living room?
Quite possibly, yes, sir.
And did you do that, sir, for the purpose of getting her to invite George and or Cindy over to speak with her and try to capture their conversation?
My recollection of that is they were asking to meet with her and to talk to her. And I believe what she had told us at that point was she had visited the Anthony home and told them that we had met with her. And after that point, she had been receiving communication some way, somehow from the Anthonys. And our concern at that time was what they would maybe ask her to say. Yes, sir.
You wanted to capture their conversations with Miss Tenelli?
If it was made available, yes, sir.
All right. And in fact, sir, did she ultimately decline, that is, Miss Tenelli declined to do that?
I don't recall that off the top of my head. I recall her being somewhat uncomfortable because she would have had to get her husband's permission. and she didn't want to, maybe that came across a little too intrusive to her personal life, is what I remember. She didn't say no. My impression was she was willing to entertain other ideas. However, that one, she wasn't really a big fan of that.
So you never did it?
That's right.
Thereafter, did you contact her again?
That would be the third time in the...
At Lowe's?
Correct.
And you and Detective John Allen and Detective Yuri Melich appeared there, do you remember?
No, sir, that was just Sergeant Allen and myself is what I remember.
Just the two of you?
Yes, sir.
And did you at that time ask her if she would in fact wear a concealed wire microphone on her person?
We may have entertained that conversation.
And was the purpose of that so that she could further try to capture candid conversations with Mr. George Anthony and or Cindy Anthony?
Possibly, yes, sir.
And did she do that?
She did not. The window of opportunity never made itself available.
That would be the proffer with respect to that aspect of his dealing with Ms. Tenelli.
And Mr. Mason, you have any questions, Ms. on the proffer?
I do not.
Yes.
Aware, sir, of any voicemail messages left on Miss Tenelli's phone by Mr. Anthony?
By Miss Anthony. I believe it was Miss Anthony. Called Miss Tenelli. She allowed us to retrieve that from her phone. I believe it was Miss Anthony. Do you have a transcript I can review?
No.
Off the top of my head, I want to say it was Cindy Anthony that called and left Linda a phone message.
Do you recall the substance of that phone message that was left?
I believe I would be more comfortable answering that question with a review of a transcript. I know that.
Did you cause a transcript to be prepared of that phone message?
I believe Sergeant Allen recorded that contact on that date, so he would have to answer that question. I myself am unfamiliar with it.
Okay.
All right, Mr. Mason. What material fact does this evidence tend to prove or disprove, or what relevancy this has to the theory of defense?
How much time do I have?
As much time as you can take.
Judge, as I said before, it does reveal only that the focus of the investigation was otherwise directed not just at the defendant on trial, but at others because of the processes of the law enforcement investigators. As to being able to establish a material fact in the absence of the recording, it doesn't.
Part two to the question. What relevancy does this have to the theory of defense?
The theory of defense, as presented to you earlier, deals at multiple levels, but as far as this would be concerned, the dysfunctionality and the circumstances involving what happened after the accidental drowning and who did what in an effort to conceal or cover that up. And the investigation carried on in that regard, and it goes to the theory of defense to suggest that the detectives involved in the case were so interested in following that road that they asked a woman to wear on 2 occasions a wire or concealed interception of communications to try to find out and get incriminating statements from the parents.
And since the next witness is out there, were they successful in getting incriminating statements?
You said, did they?
Were they able to get?
No, sir.
Okay.
No, sir, they were not, because she actually, after being requested twice, she declined to do it. What she otherwise would only be able to testify to, which is what we already have in evidence about the duct tape.
Okay. Thank you. State.
Your Honor, as I argued at sidebar, it is obvious from the proffer, as well as what was argued at sidebar in open court, that this line of questioning is designed only to invite the jury to speculate on the motives of law enforcement without actually ever asking what their motivation was to do something, because their motivation would be irrelevant, because it does not relate to any of the material facts regarding Casey Anthony's guilt or innocence. This is particularly emphasized by the fact that no evidence was obtained as a result of this law enforcement endeavor, and therefore the only thing left is the motivation, and that is not a subject that is relevant or material for this jury to consider at this juncture.
The court reporter would appreciate it if you'd be by microphone.
It's interesting, the objection based on speculation, yet we're asked to speculate that the murder weapon was duct tape and the child suffocated from duct tape.
Mr. Mason, Ms. Drain, there's no jury in here, and I can determine. I think I have enough experience to understand what goes to an argument and what does not go to an argument. So there's no jury. So the objections about arguments, folks, is just a needless waste of time. So let him finish his argument. Okay. State anything else it would like to say in concluding remarks? Okay. The Florida Supreme Court in the case of Wright versus State, 19/7 edition, 3rd page 277, a 2006 decision of the Florida Supreme Court, said that it is within the trial court's discretion to determine what is relevant evidence. It goes on to say that the requirement for admissibility of all evidence is relevancy. And it talks about the evidence code. And the definition contained in 90.401 of the Florida Evidence Code defines relevant evidence as evidence tending to prove or disprove a material fact. It is quite evident by the proffer of the testimony of the detective that this evidence does not go to proving a material fact. The second possibility is its admissibility under the theory of the defense. The theory of the defense that has been advanced at this time is that the victim in this case died as a result of an accidental drowning, and the bizarre behavior or different behavior on behalf of the defendant after this was caused by certain events that the defense espouses. This particular evidence does not go even to the theory of defense. Therefore, the state's objection to this particular evidence as not being relevant will be sustained and is not admissible under 90 versus 401 or as a theory of defense. So the deputy's testimony is proffered for purposes of the record. Do you have any other questions you would like to ask him on any other topic other than the bugging of Mr. and Mrs. Anthony?
Not at this time, Your Honor. We'll be following.
Okay, Deputy, you're hereby excused. Detective, I'm sorry. Do you still intend to call the next witness?
We will call Ms. Tenelli briefly.
Okay. Is it for a different purpose or is it for the purpose of the proffer?
Different purpose. Although he did reference part of it, I'll take out duct tape.
Yeah, the duct tape. Okay. I just want to make sure that we don't have to send these folks out again on the Pop-Tart route. All I'm asking is if there are some matters we're going to need to take up and have a sidebar, I would much rather do it now than to have the jury come back in and we have to go through this exercise again. I have no idea who this witness is and what she's going to be asked to testify about.
Step out.
Yes, sir, you may. We'll be at ease.
I want to make sure she's limited.
Okay. Yes, sir.
We're ready.
Okay. The real time is mine was back on. Okay, we'll be at ease while Madam Court Reporter takes a look at Mr. Ashton's machine. Okay, the court reporter is ready. Is the defense's real time working? Mr. Baez, is your real time working?
Yes, sir.
Okay.
Your Honor, apparently the only evidence to be elicited from this next witness is that at some unknown date and time at a command center, the witness saw Mr. Anthony with duct tape that cannot be further identified. I believe that's what was confirmed by now Sergeant Edwards. Therefore, that testimony is of no material value, and we would object when they attempted to elicit that. So I wanted to bring that to the court's attention now. If she could, in fact, say that there was a specific brand of duct tape that she recognized that he had on a particular date relevant to this time frame, I would not object, but it does not appear that the witness is going to be able to do that.
But she can say it's duct tape.
Okay.
Okay.
That's what I understand her to be able to say, but that doesn't establish any relevance.
You're saying it's not relevant because she cannot say what brand of duct tape.
Or identify when shown. a specific brand, that was what was used.
So you're saying whenever the state of Florida sees someone with a knife or a gun and can't say what type of gun it was or knife, and that the victim in a murder case was killed with a gun or a knife, that evidence is not admissible?
Not unless we can tie it into some relevant time frame that would establish its materiality.
Okay.
The fact that someone possessed a gun or a knife at a particular point in time would never be admissible unless it could be tied in to a relevant time frame.
Well, isn't she going to testify it was at the volunteer tent? Then that does not affect its admissibility. It affects its weight and whatever weight they would give. But I kind of think the defense bar would be very interested if the state would agree to that proposition of law in all of its cases. Because most of the time, most witnesses can't tell you a serial number or whether it's a revolver or a semi-automatic. All they can tell you is somebody stuck a gun in their face and robbed them at gunpoint. But that's a debate for another time.
Yeah.
That is admissible. Ready? All right, let's return to jury. State recognized presence of jury. The defense.
Yes, sir.
Defense may call the next witness.
Linda Tenelli.
Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Linda Tenelli, Linda Tinelli.
Good afternoon, Ms. Tenelli.
Hi.
Do you know George and or Cindy Anthony?
Yes, I do.
Can you tell us when and how you first met them?
When I heard Kaylee went missing, they had a command center. I went down to the command center on Publix at Lake Underhill in Chickasaw and offered my help as a volunteer.
You were a volunteer helping to coordinate the search issues, is that it?
No, I coordinated the table where they gave donations and handed out T-shirts and pins and bracelets.
And did you volunteer at that command center on occasions with Mr. George Anthony?
Yes, I did.
And at that time, those times and places, that was been during the late summer, early fall of 2008, would that be correct?
From towards the end of July till December. The last day was December 8th.
During that period of time, ma'am, did you observe Mr. George Anthony having duct tape?
Yes.
Duct tape.
I'm sorry.
Yes?
There was duct tape at the table, yes.
And do you know how it was used at that time and place?
Yes, we had like plastic tablecloths, and we would like take the tape and hold the tablecloths on because it was windy sometimes and they would blow, and we also put posters up with them of the missing children.
Okay. When you say we, does that include yourself?
Correct.
And Mr. Anthony?
Yes.
Thank you very much. Those are the only questions I have. talking about the wind blowing the tablecloths and so forth?
Correct, they were plastic tablecloths.
What, if anything, did Mr. Anthony do about that in your presence?
Well, we would like tape the tablecloths because they would go like around the tables, and we would just tape them underneath to hold them so they wouldn't blow off.
Thank you very much. That's all.
Cross-examination? None. May the witness be excused.
Yes.
Thank you, ma'am. You may be excused. The defense may call their next witness.
Defense calls Detective Yuri Melich.
You solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God.
I do.
Yes, my son.
My name is Yuri Melich, Yuri Melich.
You may proceed.
Thank you, Your Honor. May it please the court. Good afternoon, Detective Melich.
Good afternoon, sir.
Detective, as previously testified, you are the lead investigator in this case.
Yes.
And pretty much that means you're in charge of the case.
I have a supervisor I answer to.
Right. But you are the coordinator of everything?
For most of it, yes, but I also have a supervisor who has input on certain decisions that are made, and he has a supervisor that he answers to as well.
And were you first called out on July 15th, 2008?
I believe it was after midnight. Would that have been July 16th?
16th, I apologize.
Yes.
Okay. And when you were called out, you were made aware of the smell of the Pontiac Sunfire pretty early on when you first arrived.
I don't know if I would say early on. As I testified to before, at some point somebody at the house had mentioned the smell in the car.
Okay. And that somebody was George Anthony, wasn't it?
Yes, correct.
Okay. And the next day, well, let me stop you there. You didn't do anything with that information?
No, not until later that day.
Okay. And when you say later that day, you mean you were there at nighttime or early morning hours, late?
I don't believe I returned that night. We had the car brought to our central operations center later that night, or later on the 16th.
Right. What I'm saying is you arrived in the early morning hours on the 16th.
That's correct.
Then later on, after you had spent several hours there, you left.
I don't know if it was several hours, but after a short period of time, enough to do the interview, yes, I left, came back, and then left again.
How much time did you spend at the Anthony home in the early morning hours of the 16th?
By initial arrival, to include the time it took to take the original taped statement, maybe a little over an hour.
And then after that?
Just long enough to drop Ms. Anthony home after she showed me the locations.
And then as soon as you dropped Casey Anthony off, you had more interaction with Mr. Anthony, correct?
Yes, at the driveway as I was about to leave.
Okay. He wanted to speak with you privately.
I don't know what he wanted, but ultimately he talked to me at the car as I was at the end of the driveway. I was still in the car. He approached the car.
And the purpose of his conversation with you is to focus a little more on Casey, correct?
Objection. He's asking the witness to speculate on someone else's state of mind.
Sustain.
What was the purpose of that meeting?
Same objection. He's asking the witness to speculate.
He can answer from his perspective.
I don't know what his purpose was. My purpose was simply to drop her off and then go do my investigation.
Did you obtain any more information from that private meeting that you had with Mr. Anthony?
Just what I noted in my report, what he'd said.
Okay. And then the next day, I want to say, you left in the early morning hours, around 7 a.m.?
Approximately, yes.
Okay. And then you met with Miss Anthony around noon that same day?
Yes, at Universal Studios.
And how many police officers were there while you were at the Anthony home?
I can recall 2 uniformed officers and myself, not to say that there wasn't another uniformed officer present, but I wasn't really paying attention to the uniformed officers. I was paying attention more to the Anthonys and Miss Anthony.
Did you see Sergeant Hosey there?
Yes.
Did you see Adriana Acevedo there?
I don't recall who else I saw aside from Sergeant Hosey, and I recall him because I believe I had a conversation with him when I arrived on scene. I believe that was him.
Have you at any time come to realize there were approximately 7 or 8 officers there that evening?
I wouldn't believe that there were 7 or 8 officers, no. But again, I wasn't paying attention to the officers there. I believe if there had been 7 or 8 police cars, it would stand out, but that does not stand out.
Did any officer that was there that evening, whether you saw them or not, later on come to you or advise you at any time that the car should be confiscated or crime scene should be called out because the car smelled?
I don't recall.
Stay.
Now, after you actually didn't go confiscate the car until after Miss Anthony was arrested, correct?
Correct. I had already made arrangements with Mr. Anthony, and another detective went to take the car and items that were inside or had been inside the car.
So the process of how this all went down was you showed up that evening. The next day you met with Miss Anthony. You arrested Miss Anthony, and then you went and looked for the car or confiscated the car.
Not entirely correct. It was all one day. This all happened on the 16th. So when you're referring to the next day, it's all still the same day.
Okay, forget the days. But the sequence of events goes like that, correct?
That's correct.
Okay. And it wasn't until she was under arrest that you decided to look for evidence in that car.
That's correct.
And the reason you arrested Casey was because you thought she might harm herself.
The reason I arrested her was because she had the elements of the crimes what she was arrested for. Part of my determination on to make an arrest, yes, I had already explained and I had testified to, that I was concerned that she may hurt herself. And this is based on my opinion on another case that was in the media at the time.
Okay. And because that other case from the media at the time ran through your head, this was what kind of facilitated you arresting her at that time?
Again, she had already fulfilled the elements of the crimes I arrested her for. That's one of the thoughts I had at the time that I won't deny has helped me with the decision on whether to make a physical arrest or do another option. But yes.
And now, after she was placed under arrest, the focus of the investigation focused heavily on the car then.
The focus of the investigation was always to find this missing child or kidnapped child. Yes, we did focus our investigation towards the car, but it wasn't the sole point at that point or at that time.
And as part of your investigation, obviously you wanted to do a thorough job.
Yes.
And that would include looking at every possible scenario.
Correct, but keeping in mind that we were going off of what we were told happened, and that included that this child was kidnapped by a known individual, and we had all these other names to go with it.
And you were also told by everyone in the home that the child went missing on June 9th, correct?
Initially, yes. They all said June 9th.
And that included George Anthony?
That's correct.
Okay. And that later on turned out not to be the correct date?
After a few days, we were able to find out that that was not the correct date, yes.
In fact, the correct date was June 16th.
Yes.
Okay. And you had in your possession at that time all of the knowledge of this nanny, Zanny the nanny.
I wouldn't say we had all the knowledge. We had what Ms. Anthony and the Anthony family had mentioned concerning the nanny or the kidnapper. But we
And-
still had yet to talk to friends and other people that she was associated with, including these outcry witnesses, to identify who this nanny was.
And shortly after the investigation, you were able to determine that the nanny did not exist.
I wouldn't use the word shortly after. It took a while because we still had Ms. Anthony never changed her story about the nanny. In conversations that I monitored between communication to her and her family at the jail, she was still talking about the nanny. So I wouldn't use the word shortly. Ultimately, yes, we don't believe this nanny exists, but I can't tell you or I can't pinpoint a day that I made that determination beyond a reasonable doubt.
Now, you didn't have any prior contact with anybody in the Anthony family before July 15 or July 16, 2008?
Not to my knowledge, no.
Okay. You didn't know Casey Anthony, correct, prior to that date?
Correct.
You didn't know George Anthony?
Correct.
Or Cindy Anthony or Lee Anthony?
Yes.
And at that time, in July of 2008, you subpoenaed Casey Anthony's cell phone records.
I had asked another detective to do so, but yes, that was on my instruction.
And you could have also asked a detective to subpoena George Anthony's cell phone records, correct?
We ultimately did.
Okay. Do you recall which time period you asked for?
I cannot recall.
You have no idea what cell phone records you requested in this case from George Anthony?
I do, and I know that we were also working in conjunction with some investigators at the Metropolitan Bureau of Investigation. And they were assisting us with a lot of things to include getting cell phone orders, court orders on particular cell phones.
The reason you requested George Anthony's cell phone records was to exclude him from the searches that were done in March, correct? Searches on the home computer?
We subpoenaed his records multiple times. We also subpoenaed for June and July.
Really? And did you give these cell phone records to the prosecutors?
Yes.
And when did you do that, sir?
I'm trying to think now. You mentioned March. I'd have to look at the cell phone records to see which ones were subpoenaed. I do specifically remember the March ones. Perhaps I'm getting confused. I'm getting confused with the home phone records, so I apologize. I don't believe I subpoenaed George's cell phone.
Okay. So you only subpoenaed the home phone records for June and July 2008, but you never subpoenaed George Anthony's cell phone records for June and July 2008.
I don't recall, no.
Overruled at this point.
I don't recall.
Go ahead. You can
Sorry,
ask the
sir.
question.
I don't recall, sir.
And a cell phone record could tell you not only what calls a person makes, but their text messages?
Yes, depending on the company, some cell phone companies retain the text information.
What other information can you get from a cell phone record? Can you tell the ladies and gentlemen of the jury of that?
It'll tell you calls dialed, calls received, duration of phone calls, and on particular cell phone companies, it will tell you the towers that actually carried a particular phone call at a particular time.
And what significance would that have to an investigator?
I could speak for myself. It would tell me if a particular call was placed at a time and I want to get a general area of where that phone was, then it would tell me a general area of where the phone was when a call was made.
And it could assist you in tracking a person's movements,
I've
depending on the records?
I've used it for that, yes.
Okay. And you used that for Miss Anthony, did you not?
Yes.
In fact, you had them create an entire report on that.
What do you mean they?
The Metropolitan Bureau of Investigation. You had them do a month-long investigation as to the cell tower locations of Miss Anthony, where she went, and so on and so forth.
Well, we subpoenaed the records which had that information, and at the beginning of this investigation, yes, the Metropolitan Bureau of Investigation did plug the towers in using latitudes and longitudes.
And you did not do that for George Anthony?
No.
You did not do that for Cindy Anthony?
No.
And you did not do that for Lee Anthony?
No.
Okay. The only person that you focused in on with the cell records was Casey Anthony?
At that time, yes.
Okay. At any time?
Yes.
Okay. So the entire 3 years that you've been investigating this case or have had this case, you've never done that for anyone other than Casey Anthony?
That's not correct. There are other people that I've pulled cell phone records on, and I've looked at tower information to see where they were during particular times.
Who did you do that for?
Off the top of my head, I can think of one, and that was the person who actually called when they discovered the remains on December 11th.
Okay. Let's talk about that for a moment. You're talking about an individual by the name of Roy Kronk.
Yes.
Okay. Now, Mr. Kronk on December 11th is the man who discovered the remains.
That's correct.
Okay. And upon him calling, he called 911, correct?
Yes.
And
I don't know if he called it, but he called his communications. 911 was ultimately called.
That day, you immediately responded to Suburban Drive.
As soon as we were notified of the call, yes.
And when you got there, you interviewed Mr. Kronk.
Ultimately, yes.
Okay. And when you spoke to Mr. Kronk, you asked him what happened?
Generally speaking, yes.
And you asked him what he did?
Generally speaking, yes.
Okay. And you asked him if there was any other important information that he had for you regarding his activities?
Yes, this was all tape recorded in order to maintain the integrity of his conversation. So yes, it should all be on tape.
And he didn't tell you that he had called the police 4 months earlier, did he?
Objection. This is hearsay.
Sustain.
Move to strike counsel's question.
Judge, it's a negative. I'm not asking for a statement.
Hearsay.
Were you made aware at any time, or when did you first become aware, I should ask you, of prior calls to 911 from Mr. Roy Kronk?
You may continue.
During the month of August 2008, sir, were you approached by a Detective Gerald White regarding a tip off of Suburban Drive?
Yes.
And did you inform Mr. Detective Gerald White that he did not need to follow up on that tip because that area had already been searched?
Objection leading.
Sustain, rephrase the question.
What did you instruct Detective Gerald White in regards to that tip, sir?
What I recall, the tip was very general, and we had already sent a cadaver dog, Deputy Forgy, in that general area. So I told him that the area had been searched.
Okay. And as a result of which, did you instruct him at that point not to follow up on that tip because that area had already been searched?
As a result of our conversation, yes, he did not follow up on the tip, and that was because he approached me and asked me at the tip. So I told him, yes, we'd already sent people to the area, so just mark it down and go to the next tip. We were getting hundreds of tips.
Okay. Now, the gentleman, Mr. Roy Kronk, you mentioned that you had gotten his phone records.
Yes.
What day or dates did you get his phone records for?
I can't recall off the top of my head. It would be on the subpoena when I made the request.
Okay. Do you have that with your case file?
I don't believe I have it, no.
Okay. Do you know if you asked him for, excuse me, let me strike that question. Did you subpoena his phone records for 2 weeks, a month, 6 months?
Going on memory, I believe I subpoenaed it for June through December of 2008.
And did you turn over those cell phone records to the prosecuting attorney's office?
Yes, I would have turned over all records I got on this case to the state attorney's office.
June through December. Of 2000?
I believe so. That was the date range.
Okay. And does these cell phone records include cell tower information?
Yes, I believe they do.
And did you have a report run for that cell tower information?
When you say report run, I make the request from the cell phone provider, and they provide me the information. And when they provide it to me, I am able to actually get latitudes and longitudes based on their tower. So there's no report created aside from the one the phone company provides me.
Okay. Did you give that to the same person who prepared the report for Casey Anthony's cell tower movements?
Who prepared the report for her cell tower movements? I'm confused. Are you referring, did I give this to MBI?
Yes, I'm
No.
asking. Okay. Did you instruct someone to observe the movements of Mr. Kronk during that 6-month period?
No, I used that information to answer questions I had about where the cell phone was at a particular time.
Okay. Now, the subsequent to the remains being found, you were aware that there was duct tape found off of Suburban Drive.
I recall there were a lot of calls at the end of Suburban and in the dirt road towards the end.
You misunderstood my question.
I think I did, yes.
At the recovery site on December 11th, crime scene investigators recovered duct tape near the remains of Kaylee Anthony.
Yes.
And several months later, it was made public on a news report that there was video taken of duct tape at the command center where George Anthony was manning the command center.
Yes, I remember that.
Okay. So you discovered by looking at that video that it was the same brand of duct tape.
It appeared to have the same markings as the duct tape we found on scene, yes.
And these are the markings of the Henkel logo, which is the name of the brand of the duct tape.
Yes, that's correct.
Okay. This is somewhat unusual duct tape, right?
I had never seen, personally, duct tape with a stamp or logo on the non-adhesive side. So to me, it was unusual. I had never seen something like that.
And when did you go back and interview Mr. Anthony as to when and why he had duct tape that was found at the scene off Suburban Drive?
I did not.
So you have never gone back after finding out this evidence and interviewed Mr. Anthony as to where he got this duct tape from and what was going on with it?
Objection asked and answered.
Sustained.
After this news report came out, you were also aware that the only piece of duct tape found at the Anthony home was found on this gas can, correct?
That had that Henkel marking, yes.
And
what?
283, Your Honor. And as far as the evidence that you had relating to the duct tape, you knew you had duct tape near the remains of Kaylee Anthony, correct?
Yes, and on her remains as well.
Okay. And you knew that duct tape was found on this can?
Yes.
And you knew that there was no other duct tape anywhere in the house that was from the Henkel brand that matched the duct tape at the scene?
Yes, at the time of our search warrants, there was none.
And the only other piece of duct tape that you ever saw, other than those two, was the one on this video?
Yes, that I can recall, yes.
Three pieces, or three different locations, well, I know there were multiple at the scene, but three different locations, three different sets of evidence, correct?
Yes, generally, yes.
And you were also aware that this gas can was reported on June 24th, 2008, as being stolen by George Anthony.
Objection, leading and hearsay.
Sustained, Mr. Leedy.
During the course of your investigation, did you investigate as to whether there were any police reports maybe reporting a gas can missing from the Anthony home?
Yes.
Did you determine that this was the gas can that was missing?
Yes.
And this was the gas can that ultimately had the duct tape on it?
May I see the can?
Yes. May I approach the witness?
You may.
The tape has been removed? The tape is no longer on it? Or is it hidden under? It appears to be the same gas can on the photo. I don't see the tape on the can, though.
And you're looking at photo 107? States 107?
Exhibit 107, yes.
Now, during the course of your investigation, you actually interviewed Mr. Anthony on July 30th, 2008, correct?
I believe that was the date, yes.
Okay. And that was the first time that Mr. Anthony had informed you of some sort of a fight with Casey and this gas can.
Objection, hearsay.
Sustained.
Did Mr. Anthony at any time ever inform you that he had reported these gas cans missing?
Objection, hearsay.
I'll withdraw the question, Judge. Was the very first time you had these gas cans collected August 1st, 2008?
I'd have to refer to the property form. I wasn't the one that went to collect them. I believe it was one of our crime scene investigators.
Would you have collected it immediately after? When? Why would you have gone and collected these gas cans?
Shortly after, Mr. Anthony would have told us that.
Objection to hearsay response, Your Honor.
Sustained.
Without telling us what he told us, would you have waited a while after? How long would you have waited before collecting these gas cans after being informed of an incident?
That's a difficult question to answer, of how long I would have waited. I can't recall specifically when he first told me of the cans. I can't recall, unless I see a property form, what date the cans were collected. It would have been within a reasonable time, I believe. I wouldn't have waited months, obviously.
Okay. When you say a reasonable amount of time, you mean days?
Yes, going by memory, I believe it would have been within days.
Maybe even 24 hours.
Again, without those two pieces of information, I hesitate to answer that.
Okay. Do you have that with your case file today?
I can check my report to see if it's in my actual report.
Go ahead and take a look.
Were you saying the gas cans were collected on August 1st?
Yes.
Reading the narrative of my report, I don't have anything on August 1st for the gas cans, so again, I would have to look at the property form just to confirm that that was it.
May I approach the witness, Judge? I have one on there.
You may.
Fortunately, Detective, I just have it on computers. Does that help you?
Yes, ma'am. Yes, August 1st.
One final matter on, you said you got Mr. Cronk's cell phone records from June through December of 2008. Correct?
Yes.
Did you also confiscate his computer?
No.
Could his computer have told you more information as to his activities within those 6 months? Do you confiscate computers during the courses of investigations?
As a general rule, yes, if I believe the computer can provide me information related to the crime committed.
Okay. And sometimes computers can tell you what emails are sent.
Yes.
Sometimes computers can tell you what internet sites someone is visiting.
Correct.
Maybe when they do Google Maps as to locations and things like that.
Yes.
Anything that actually a computer tells you quite a bit about someone's activities on the internet, do they not?
It tells you about the computer's activities, yes.
And what else did you do to investigate Mr. Roy Kronk?
What do you mean?
You said all you got was his phone records. Did you do anything else to investigate Mr. Roy Kronk or any of his actions?
We obtained statements from him. We obtained statements from his co-workers. Obviously, we've gotten his cell phone records as well for a period of time.
Okay. I have no further questions at this time.
Cross-examination.
Just very briefly, Your Honor. Detective Melich, you referred to having been provided a tip by another detective by the name of Gerald White.
That's correct.
Okay. This is a co-worker of yours, or at least was at the time, in the homicide unit?
Yes, correct.
You indicated that the tip itself was very general in nature. Did it mention Suburban Drive?
Yes, it did.
Did it mention the tip itself that you saw, did it mention a particular location on Suburban Drive?
Swampy area near a 6-foot fence or across from a 6-foot fence.
Okay. Now, you were familiar at that time, which was August of 2008, with the fact that Suburban Drive was near Hope Spring Drive where the Anthonys resided, correct?
Yes.
And at that point, in August of 2008, Orange County Sheriff's Office efforts as it related to Suburban Drive dealt with the dead end where Suburban stops just short of woods, correct?
Yes, the far east side of Suburban Drive where it dead ends at the school.
Okay. This is Hidden Oaks Elementary?
Correct.
Okay. The site where Kaylee Anthony's remains were ultimately located would be between Hidden Oaks Elementary and the Anthony home, correct?
Yes, much closer to Hope Spring than it would be towards the dead end.
All right. So when you were responding initially, or at least ultimately, to the tip information that was given to you from Gerald White, you believed that the end of Suburban Drive had been searched,
yes.
Correct?
Correct.
And you had mentioned Jason Forgy and his cadaver dog. Do you have knowledge as to whether or not that was the location past the school, past the dead end, that the dog had been deployed?
Yes.
That's all the follow-up I wanted to do on the testimony list.
May the detective be excused. You're excused, detective, subject to recall at a later time. That's it. Okay. Do we need a court reporter? Okay. Okay, ladies and gentlemen of the jury, the time is now approximately 10 minutes to the hour of 5. We're going to recess for the balance of the evening and return back here tomorrow morning at 9 a.m. Please do not discuss this case among yourselves nor with anyone else. Any additional instructions on behalf of the state or the defense? We'll be in recess to 9 a.m. Members of the jury, you may be excused. You may be seated. Okay, a couple of housekeeping matters. Mr. Baez, when is your best guesstimate of when you think you would be winding up your presentation?
At this time, we believe Wednesday or Thursday. So if I had to give a date, I would say Thursday.
Okay. State needs to have, the state going to have any rebuttal? Do you have any idea at this time approximately how long it will take for rebuttal?
I was going to say 1 day, but perhaps 2.
Okay. Do y'all have any idea of how long you would be asking for closing argument?
That brings up an interesting issue, Judge. The state had requested once at a pretrial hearing the request to split up the closing arguments with lawyers, allowing multiple lawyers to argue at different, parts of their closing arguments. This would essentially give the state of Florida 4 opportunities to make closing arguments. We would object to such a structure. However, I'd like the court's guidance as to whether that's going to be allowed, and then we would know how to proceed accordingly at that point. I just think 4 closing arguments is going to be
How do you get 4 closing arguments out of the fact that the state only gets opening and then a rebuttal argument after the defense is spoken?
If they're allowed to split it up between lawyers, they essentially get 4. One lawyer goes up and talks, then the next lawyer goes up and talks. That's 2. The defense, if it chose to follow that structure, would get 2. And then, of course, they could do that again in rebuttal. I think my conversation...
I don't intend to allow but one lawyer up on rebuttal. You will not split the rebuttal argument. I can understand splitting the opening argument, but there's no need to split rebuttal, so you wouldn't have to worry about that.
It's their argument as well, so they can have as many attorneys as they'd like on their closing.
Okay, getting back to my question. All I'm asking for is a guesstimate on how much time, state how much time would you be requesting. I'm not going to hold you to it now, but off the top of your head, how much time you think you would need for your closing? Okay. Mr. Baez?
I was going to be expecting less than that, but I would think...
Half a day or until the jury goes to sleep, whichever occurs first.
We've got lots to play. So they take that long.
Knock yourself out. Whatever time you tell me you'll need, I'm going to hold you to it. So you can speak until you get tired or the jury goes to sleep, whichever occurs first. Okay. Okay. Are y'all, I will probably give you on Monday an order dealing with closing argument. And are you familiar with a reference that I have used for years? Former Judge Ferrer's compendium dealing with closing argument. If you would like, I would email it to you. It's a very good resource. I've used it for years. It's a resource that is utilized by all of the circuit judges in the state dealing with what you can and cannot do in closing argument. But I will be issuing an order Monday giving you some basic parameters. But if you're interested in it, I will email it to you. But it's very long. It has just about every case known to mankind, dealing with all the areas. Okay. Mr. Baez, you said there was some discovery violations you wanted to talk about?
Yes, sir. Detective Yuri Melich testified that he obtained phone records for Mr. Roy Kronk from June 2008 till December 2008. We have only received, I believe, 2 weeks of cell phone records for Mr. Roy Kronk, which I believe are June 16th through July. Excuse me. We don't have the rest. And I consider this a major violation if, in fact, Mr. Melich was testifying truthfully. He also testified that he had the phone records of George Anthony during that time period. We don't have those as well, or any of the other Anthony family members. I'm quite shocked to hear this information, and would request to find out if this is actually true, inquire by the state if they have made inquiries on this topic, and where these phone records are.
State, any response?
My speculation is that the records that they may be looking for are contained on the disks of information that they've been provided. However, it's my understanding that counsel has subpoenaed all of Mr. Kronk's records, asked for a court order, and had Mr. Kronk's lawyer respond to the request for a subpoena, and the court placed some parameters on that to avoid a fishing expedition. Nevertheless, I will inquire of Detective Melich if there are items in his possession that are not what was turned over to us. He and I spent a great deal of time going through his file and comparing it to what I already had and had turned over. So I will do that. This is the first I'm hearing from Mr. Baez that he believes there's something missing. As it relates to this allegation about the Anthony's phone records, Mr. Baez, provided those to me. So if there's something in addition to that he thinks Detective Melich has based on the testimony, then he and I can speak about that. But I believe ultimately Detective Melich testified that he received home phone records of the Anthonys. But we can certainly compare. I am unaware of any intentional discovery violations, but I can continue to work with Mr. Baez to compare information.
Anything else, Mr. Baez?
I know we tried to get the cell phone records, but if I fully accept that, if Mr. Verdict can double check, and then would obviously have to recall the detective to set him straight.
Well, you talk about there was some court order with Mr. Crunk's record, I guess that predated me.
He had asked for
Okay.
records from a lot of individuals. Many of them had lawyers. They had a full-blown hearing about the scope of any subpoenas. So, yes.
The rules of discovery contemplate a couple of things. It contemplates that the state provides, one, things that are in their possession that they intend to perhaps utilize in trial, reports of experts, and things of that nature. There is something besides the rules discovery called Brady versus Maryland, which you file a motion, at least on 3 occasions that I can remember, asking for Brady material, which requires that the state provide any information that may be exculpatory to the defendant. The rules also provide that you have the right to subpoena certain records on your own, and it looks as though you may have subpoenaed phone records. I don't recall the state trying to introduce anyone's phone records that they did not give to you. And so that wasn't an issue during the trial. The only issue would be if those records were exculpatory, which I cannot say since I'm not familiar with the records, and the state hid them. The bottom line is if you need records, try to get them, but it's a little late in the day to be going after red herrings. But if there are exculpatory things, then you know what happens when they're exculpatory. So, and that's all I'm going to say. Anything else we need to take up?
I guess it's a requested instruction about Dr. Rodriguez. I don't know if you want to talk about that now or tomorrow morning.
That's up to y'all. I'm here.
Mr. Mason, which would you prefer? Talk about this now or in the morning? Suggested instruction. It is, first of all, a comment on evidence not before the jury to the extent that it seeks to indicate that Dr. Rodriguez, quote, will not be resuming his testimony because his employer, the Department of Defense, will not permit him to testify in the current proceeding is not wholly, it's not before the court. It is also not wholly accurate. I think it would be better if the court did not announce to the jury facts not before it, but if it does, the correct fact, as I know it, would be that he is not, that his testimony was prohibited pursuant to the rules and regulations of the Department of Defense, and therefore he was testifying in violation of those rules and would not be permitted to do so. I don't think the defense wants the jury to be told that. So perhaps we should simply come up with a instruction that, in a more bland way, advises the jury that he was withdrawn because, as the court noted, the defense could have subpoenaed him and forced him to testify since he was here, and they chose, and I applaud them for not trying to ruin this man's life over it, but they didn't. So I think a more appropriate instruction would simply be something that announces that he's withdrawn as a witness and the jury should disregard any testimony he gave, because I think that more accurately reflects the reality.
Your Honor, you may recall that it was Mr. Ashton who stood in that room with all of us and told us that he on Saturday had a phone call from the boss of the Department of Defense advising him, it wasn't Mr. Ashton's doing, it told him that Mr. Rodriguez would be terminated if he testified, and that information was not passed on to us until that part of the day after his deposition, in fact, had been taken the day before on that. And the only reasonable conclusion is exactly as we all talked about. Yes, you could have forced him to stay. In fact, I suspect if we had asked to, you could have declared him a material witness and had him put in jail to stay
That's
here.
true.
But obviously, we were put in a situation of dealing with reality and humanity and ethics not to do any of those things. I don't want it to read it's like he just withdrew or just didn't do it, because that's not the case. Well, you were there. You heard it. So,
but it's also true, is it not, that what was represented was that he did not get the permission of them to testify. And that was the reason why.
I don't know that Mr. Baez talked to him. I didn't.
We don't know that, Judge.
Well,
all we know is this. We know that he came, he began his testimony. Of course, we had the break. Mr. Ashton took his deposition. Somehow Mr. Ashton had a phone call with the Department of Defense on a Saturday. The next day, he's shaking in his boots because he's going to get fired.
Let me clarify the implication of what counsel just said, just so it's clear. I received a phone call from Dr. Rodriguez's employer at the Department of Correction, a Department of Defense, a Captain Melich. I did not solicit his contact. He informed me that they had learned of Dr. Rodriguez's participation by seeing it on television, that it was in violation of Department of Defense regulations, that he did not seek their permission, and that he was ordered to return home. And if he testified, he would be fired. I informed the court and counsel of that in an off-the-record discussion outside as a courtesy so that the witness would not end up losing his job over this. Any implication in counsel's comment that I contacted them is absolutely 100% false.
There's also more to the story here, Judge. Mr. Ashton also requested an additional 24 hours so he could review a deposition that he just took, knowing full well that Mr. Rodriguez was in the hot seat. So we're going to have a motion in regards to that forthcoming. But this is the most accurate representation of the events that transpired with regards to Mr. Rodriguez.
Since the facts are quoting me, I think I'm the most accurate. The point is, the facts are not before the court. The court needs to simply inform the jury that the witness is withdrawn, which is factually and legally accurate, and the jury should give no regard to his testimony and leave it at that. If counsel wants to file something under oath, bring it on.
We will.
Well, the only thing I'm going to say about it is this. In order for me to craft something other than something that is based upon what I know, which is very little, is that you're going to need his captain to testify, and they don't need to do it in person. We can do it at a break after 5 or early in the morning before 9 o'clock, and Dr. Rodriguez, and we can find out, one, whether that is a regulation by the Department of Defense, and 2, whether or not the good doctor sought permission to do this. If not, because I offered on Saturday to order Dr. Rodriguez to be held over until Monday to testify since he was in the jurisdiction of the court. And if he would have been held here on his own, and if someone had echoed that they felt that despite my written or verbal order to him that they had reason to believe that he would flee the jurisdiction of the court, then I would have ordered him held in the Orange County Jail until such time as he would testify to assure his availability. And if memory serves me correctly, the defense then said they did not want the man's job in jeopardy, that you had, quote, another witness that could testify basically to the same thing that he was going to testify to, and that you were going to let him go. So if we're going to tell the whole story, we will tell the complete story, or tell a very benign thing that his testimony is to be stricken, and you're not to consider his testimony, the little that he did give, and you're not to speculate on the reasons why, and it will be very benign. And I can craft that, and I will give that. And that will be end of story. I will have proposed jury instructions for you to start looking at probably on Tuesday. You can have them on Wednesday after you look at the proposed jury instructions, or Thursday. The way it looks like, the defense is going to wrap up Wednesday. I would like the state to have some witnesses on standby unless they're coming from out of state, so we can get started Wednesday. And you said you would take a half a day, but probably a full day. And that means that if you take Wednesday or Thursday, and you're going to take a whole day to close. Pardon?
The openings took a full day, so I don't anticipate that the closings plus instructions would be any less.
Well,
more, but I wouldn't anticipate that the
I'm
closing would take less than the opening.
I'm trying to decide whether or not I want to send them out Friday evening, or whether or not I would like to bring them back in fresh Saturday morning and instruct them and send them out. Because if we send them out hypothetically Friday starting at 5 o'clock, we're going to probably end their deliberations between 6:30 and 7 and send them back. And I have to keep them separate from each other from that point on. So let me think about that, whether or not I want to get them started, or whether or not I want to bring them in and instruct them on Saturday morning. Instructions will probably take 45 minutes. But that's something I need to think about.
What lesser included offenses they want?
The
at
lesser,
some point?
yeah, y'all have any idea at this moment, the ones that I had included is depending on renewed motions for DV. Currently now what's in there are both theories of first-degree murder and felony murder. After that, second-degree murder, manslaughter, going to count two, and I'm just doing this all on memory, aggravated child abuse with the less of child abuse, battery. I'm just going off memory. I may not have battery in there. Under the aggravated manslaughter, just aggravated manslaughter, because there will be an instruction on interlocking verdicts that I would have to give them. And then there are no lessers for providing false information to a law enforcement officer. But think about any other lessers you may be inclined to ask for. But what I do is I get that to you Monday morning because I can finish that over the weekend. Okay. Did you provide the state with this new motion you filed? Okay. Madam Clerk, I'm going to ask you to, when do you intend to argue this? Set it for hearing, Reverend. Okay.
Privately, I don't want
Okay. Remember, folks, that this particular motion to dismiss is an evidentiary hearing. So you're going to need motions to prove up the allegations other than attorneys flapping their gums. That's fine. You just, it's an evidentiary hearing. I'm not going to interrupt the trial. So you figure out how much time you need. If you need 30 minutes, then you can do it in the morning, starting at 8:25. Or if not, you can do it at the conclusion of any day's worth of testimony.
Yes, sir. We'll take the name, and we're gonna, and we can inform the court when we're ready to have that heard.
Okay. Anything else for the good of the order? Okay, we'll be in recess to 9 a.m. tomorrow morning. If you want to bring any matters up, notify the court deputy at 8:30. Second, so all minds will be clear for tomorrow. We will break at 12 o'clock for 1 hour for lunch, and then we'll go to about 3:30. Defense? If that's going to change, you need to let me know, because I'm going to make arrangements for the court deputies to feed the jury here. So we will stop at noon, have somebody from your staff order you a sandwich, and we will have 1 hour, and we will start back at 1 o'clock. Okay, see you in the morning.